Well, hello there, you fine lasses and gents. Happy St. Patty's Day. Hope you have a splendid time. I think that's about as much Irish as I can possibly swing, but it's fun to try. So, how are we doing this evening? Hey everyone, happy Friday. I'm not late, I'm on time. I am showing up exactly when I want to be and need to be because it was a week. It was indeed a week. How we doing? How we doing? Do you guys enjoy your St. Patty's Day? Did you enjoy your week? Did you have a good time? It is 8:09. It's pretty late. Late and Friday. That's what it is, Ian. I'm sorry, Ian Paler. It is what it is what it is. We go when we can and we pull up as much stuff, and I have a docket tonight. My word, we are going to have some fun this evening because there's a whole lot to cover. Make sure I've got this one. Uh Molly Mara. Lost my brother last night, sending thanks because we bonded over Dip V. Heard. He too was bipolar and an addict. He got clean in the end. Thank you for sharing that. I'm glad that you're here. Hopefully you can find a little bit of a disconnect in the chat tonight. And I know the chat's going to be there to help you out as well. So thank you for sharing that. Very much appreciated. Well, welcome. Happy Friday to everyone. I hope you all had a wonderful week. What are you guys doing? Where are you tuning in from? And what are you drinking this evening? Anything Irish on the menu? Do we have any lovely corned beef that's being cooked? Fantastic. Vez Mojito in La Belle Provence. Wonderful. Diet Pepsi. That's awesome. Fantastic. Bought new yarn to continue to learn to crochet. That's something I still have to pick that up. I am still working on my Woobles thingy, the little dino. I pick it up every now and then I have to relearn all the way from the beginning. Mary Lou Craft, sick and sewing a historical corset. Well, the sick part is awful. The historical corset part's pretty cool. That's pretty neat. Hey, Rob and everyone drinking coffee in Nova Scotia. That's always wonderful. XEDA, I'm sorry we couldn't connect in DC when you were here. I'm really sorry about that. But you're back home. You're homesick, recovering from vacation and travel. Travel is fun, but it does take a lot out of you. So let's see. Potatoes, never corned beef. Oh, come on. Corned beef is delicious. I love. Here we go. Hold this up. 1 second here. Bop it. Exactly. The puppers is never wrong. Green tea with a Reuben sandwich. Reuben sandwiches is my favorite sandwich. I will fight people. Reuben is a properly cooked Reuben is fantastic. Normie, hello from Portland. I'm about to drink a whole bottle of wine. Oh my word. Steak and salad and rum and ginger in Runkville. That's cold. It's cold. Lots of crochet tutorials on YouTube. Yes, there are. Sometimes it's overwhelming, but it's fun. I like trying that. Fish and chips and Sam Adams in Western New York. Wonderful. Cranberry flavored water in Albany, New York. I love this. This is great. Anyone having any well, I mean, I hate to say that Guinness is the Irish beverage of choice, but there's Smithwick's Guinness. Drink what you're happy. Drink what you're happy drinking. Enjoy your day. Enjoy your life. Reubens are awesome. I love Reubens. Reubens are fantastic. Yeah. Reubens are what I made with the corned beef I smoked today. Thank you, Patty Cakes. Reubens are delicious. They're fantastic. You mispronounced that sandwich. It's called a Cuban. A Cuban sandwich is very different. There are pickles on a Cuban. Cuban are delicious also. So we have a docket that we have to go through today that's quite substantial. A lot of it's going to be catch up. A lot of it's going to be a lot of fun. And then some of it's going to be some new material that we have not covered yet. We've got YouTube scandals. We've got, what else do we have? We have YouTube scandals. We've got FTX leaving their TikTok page up. Surprise. We've got Michael Irvin, that football team from Dallas that I don't talk about very much because, well, reasons. One of their former legends has a defamation lawsuit, $100 million defamation lawsuit that we're going to walk through. And then we've got some other stuff that we need to talk about, including moose antlers being used as a murder weapon. Sometimes reality is stranger than fiction. It really, really is. Greetings from Chicago suburbs. That's wonderful. How was your week? Corned beef is gross. No, it's not. That's it. That's just improperly cooked. I think that's what it is. Philly cheesesteak and lime water sounds fantastic as well. Love corned beef, but Reubens are out because I'm allergic to cabbage. I'm sorry about that, but allergies are allergies. Let's trash the Cowboys. Another stream. We have plenty of comments that we can make about that team that uses a star as its logo, and the fans that follow said team that like to call themselves America's team. But tonight's not about that football team. It's about a certain star in that football team. So, moose antlers. Yep, moose antlers. Was the moose attached? No, it was not. You moose be kidding me, Rob. I am not. Rob, what are you drinking? I am having a little bit of a vodka with ginger. It is wonderful. Yeah. Little Lamb, Rob, my Cowboys fans' mom is in the too. You know what? Football is football. Basketball is also basketball, and basketball can break your heart. My NC State Wolfpack lost today, unfortunately. But, March Madness is March Madness, and you have some fun with it. Mary Coppola, thank you very much. Maryland Crab Cakes in Virginia. Oh, Ravens. Well, Ravens, Lamar Jackson, I don't know. There's rumors that he might become a Washington quarterback soon. So we'll see. But Ravens, it's I can't really hate them. I did like when they won the Super Bowl. Mordu Parliament. Hello from Canada, drinking dry vodka from Ukraine while winding down from this rough week. It was a rough week indeed. Susan, thank you. Caipirinhas. What is that? How do I spell that? I got to look that up. Looking up using the Google machine. You can do two things at once, Rob. Caipirinhas. That is the Brazilian's national cocktail. Is that really Brazil's national cocktail? That sounds lovely. Let me see. Let me read what's in this. Let me actually, I'll pull one up and I'll show you guys what's in this because this kind of looks kind of cool. Let's see. All recipes. No, that recipe looks junk. Wikipedia. I don't trust them for anything. Liquor. There's a liquor.com. You guys, there's a liquor.com. I didn't realize there was a liquor.com. This is a caipirinha. Chances are high you've encountered Brazil's national drink, the caipirinha, if you've traveled to South American country. What is it? It's easy to make cocktail. Contains fresh lime juice, sugar, and cachaca. Okay. It looks good. So, cheers. I hope you enjoy it. That's wonderful. Thank you for sharing. It was not in Canada. Our moose antlers are, yeah. It was in Minnesota. That was where that was. The NC State loss was hard. I didn't like watching it. It broke the heart a little bit. But you know what? That's a team that's been doing pretty well the past few years, so I'm happy about it. Corned beef yum, cabbage yum, Reubens yum. Sadly, there are very few places that offer it. In Austin, I'm sorry, Cheryl. You can find one, though. You can make one. Corned beef is not hard to make. It really isn't. It's great. Rob, look at the chat. Rob, how do I spell that? I had to look at the chat to spell that. That's what happens. Love mojitos. They are delicious. Connie Fell, thank you. Hi, can I bribe your squirrel brain to cover medical malpractice? First acorn, Michael Jackson's ex-doctor did everything we're taught not to do. I've seen some of the reporting on that. Honestly, one of my really good friends from law school, previously an MD before he went to law school, some people just, they can't just be satisfied with the MD in itself. So they wanted to go to law school as well. But now he does, he advises hospitals on litigation. So I'm curious about that. And I might need a friend to help me figure that one out. Went to high school with Haloti Ngata. I love the Ravens Super Bowl win. It was a fun game to watch. Shepherd's pie. I freaking love shepherd's pie. It is fantastic. So yeah, and for those of you guys just tuning in who haven't ever caught one of these Friday Night Frenzies, for the first few minutes we like to chill out, hang out, talk about what we've been doing this week, because the week is hard and Fridays are the time when we decompress from difficult weeks, because sometimes every now and then, well, you know what, there's a video I have to explain this.
Girl boss too hard, and I have a real job with real responsibilities, and like people keep emailing me and asking me questions, and I don't know the answer, and I'm just really stressed out, and I don't want to girl boss anymore.
Yep. Sometimes we girl boss too hard, and emails and all of the like, and especially when every now and then all of the cases that you're handling and all of the cases that are high conflict cases decide they want to be high conflict on the day when you don't want them to be. Joshua Ten Hog, thank you. Rob, question. If you could go back in time to a trial, which one would it be? And would you be the prosecutor or the defense? And why this trial? I assume you're talking about the Zachariah Anderson case, because that case has been, I have not covered it because I'm like 29 or 30 witnesses in, and I feel like covering it is not doing really justice to the case. But the personalities in that trial are driving me wild. Everybody. The defense's behavior, the prosecutor's behavior, the defense being the defendant. I don't really have an issue with the defense's attorneys, more the defendant engaging in some stuff that's kind of annoying to see. But again, the witness / the victim in the case is sitting in the back of the courtroom making gestures. That case is wild. I want to see what happens. Judge Schroeder is judging that case, so we'll see what comes of it. If I could go back in time, what trial would I want to see? Well, we've covered a lot of those on Trials of the Century. I think the one that I would have wanted to see would have had to have been a Clarence Darrow trial. I'm trying to think of which one. Sacco and Vanzetti, when he gives the closing argument against the invocation of the death penalty, was epic. As was the Scopes Monkey trial for the Clarence Darrow show. I think maybe Sacco and Vanzetti. I don't know. That's hard. The McDonald's case is one too. There's a lot. There's too many. I would have loved to be a spectator in the courtroom when either F. Lee Bailey was making an argument or Clarence Darrow was making an argument. I love those historical trials. I really do. Caitlin Moore, thank you very much. My mom was a doctor at the same hospital as Michael Jackson's, and it was a bad time there when he passed. Every MD was sus of MJ's private MD and what actually happened. I do remember a lot of reporting on that. I would have to look into it more, but I do remember a lot of reporting on that. And I'm curious to take a look at it. I think that'd be kind of interesting to see. Susanna Bunnequatch. It's my birthday. Happy birthday, Susanna. Happy birthday to all of the birthdays, the St. Patty's birthdays. I think that's got to be a special blessing when you're born on St. Patty's Day. But so to all of those celebrating a birthday today, to all of those who have celebrated a birthday this week, and to all of those who are celebrating a birthday this weekend, I wish you the best of birthdays. And I hope that you enjoy both the day that you celebrate the birth and your new year on this earth, and the week that embraces that birthday and the year that comes to follow. I wish you all the best, and I am sure that this year will bring more blessings than the last. So happy birthday, Susanna, and cheers to you indeed. So, my mouse decided to stop working right now. That's always fun. I love when that happens. It's my favorite thing in the world because I can't scroll or do anything with the chat. So we'll see if we can't get this thing oh, there it goes. Against Tide, I found out I'm part Irish a few years ago. Don't know if I can get into the Irish food. I know I'm half Latina and I like Mexican food. I will tell you this. Here's the thing. You can add some Latin spice to some Irish classics and it doesn't hurt the meal. But just like Hispanic food, a lot of it is meat and starch. It sticks to the bones, makes you feel good, warms the soul. That's what it is. Caesar's in Edmonton. Where's Ian? Ian's hanging out in the back right now because Ian has someone who's running a vacuum in his house. I'll bring him on. Second I see that elvish face pop up on screen, I'll bring him up and we can hang out with him as well. Hey, Rob, greetings from India. It's 5:50 a.m. Oh my gosh, it's been a long Saturday morning for me. Just like that, to give you guys greetings. Let's see. I was going to say, so long mornings are always mornings. No vacuum. But I see a face that's really close to the camera, and he keeps jumping off screen. Mary Coppola, thank you. Oh my gosh, the Anderson case, they allowed a video of court TV for the defense. The prosecutor was mouthing the answer to a witness simultaneously. That was a very odd moment in trial. If I make it through the docket, oh, may the luck of the Irish be upon me. If I make it through the docket, maybe I can pull that video up. So it'll be interesting. Ian would like to say hi because he's not on camera, but he has audio. Ian,
folks,
I brought you on to say hi.
Hey folks, how are people doing? I'm just fidgeting around trying to get ready for a I've got an event tomorrow, so I'm in my garage and I'm not on camera. Nobody needs to see. It's a mess.
Yep. And we have lost Ian. That was not me. No, he's back. So when Ian gets his firearm situated, I have a special treat that I have to show Ian. It was a building I drove past on my way back from court this week. So when he gets stable internet, and that's an incentive for him to pack quickly so that we can get to that. So we'll go through that one. Jesse Charles, thank you for the super chat. Trying to spread joy. I start treatment for breast cancer next week, and my last work task is to give evidence in court first time. Jesse, I am one, thank you very much for sending and sharing. Two, giving evidence in court is never easy. And I can only imagine that it was stressful at the very least. With regard to the cancer treatment that you begin next week, please know that there are thoughts and prayers with you as you go forward with that. For those of you all who do not know, I lost my father to cancer a few years ago. F cancer and the horse that she rode in on. But keep yourself healthy, keep yourself fed, and keep pushing through. You're stronger than any disease that can come up and try to take you down. So cheers to you as you begin that venture. Ian, I'm going to mute you for a bit. Yep, you already got it. But cheers to you, my friend. And
I've just realized I'm making noise. So.
Okay, we'll keep you muted. Keep you muted until you get to a place where you're not shuffling all over stuff. What is Ian doing? Ian is packing for a shooting competition that he randomly jumped into and joined onto. So he's scrambling around his house gathering belongings that need to go into a bag. Bop it. Thank you. I may be a puppy, but my mom is Irish and she makes the best Irish stew. She puts Guinness in it. That's delicious. And we've got some other cheers. Good luck. Cancer sucks. Best of luck, Jesse. F cancer. Indeed. F cancer. Jesse, you've got this. And you've got a whole crew of people that are backing you along that journey. So cheers to you, my friend. And another one. There's for Jesse. A bunch of hearts for you. Okay. Don, sir. Hi, Rob. Happy St. Patty's Day. This is a very long week. Ready for a massive drink. Cheers. Me too. And we've got some stuff to cover. So what do you guys say? Do we get into it? Do we roll the intro and get stuff going with some of these cases? Because, and then actually, let me do this. Let me post a poll in the chat and I'll come back and we'll answer it. So let's see, what case do we want to cover first? Which topic shall we tackle first? And your options are Michael Irvin Defamation. Then you've got FTX YouTube influencer suit. Then you've got robot lawyer sued.
Man, the timing of my Monday streams is bad because you're going to cover all sorts of things. Then I'm going to be like, we went over this before.
I'm not. And then we'll do one here. It's going to be speed run updates. And the speed run updates, for those of you guys deciding whether and how to vote, speed run updates are Rust, which I know Ian has covered already. So we're just going to do a recap on that one. FTX disclosing how much Mr. Bankman-Fried made in the last few years. What was wrong with the recap one? My gosh, my brain. Where's my notes? Where's my notes? Where are my notes? I found my notes. Tiger Woods was a recap part. So basically, we can do a quick rundown of the recap on those, or we can get into one of the heavier subjects. Yep. That's the number. So we've got some stuff. They're in my notes folder. Sometimes they're fun. Yeah, my notes folder is wild because throughout the week I pull different little clips, such as this one.
You getting big?
Getting too big for his britches. And he's like, hold on, I got a little itch.
You know,
that last move over there. Oh yeah!
That's going to be way less cute when he gets big.
oh, I know, but it's really cute right now. Yep. And let's see here. Where was it? Just Aaron, this is why you're always late. Sometimes, yeah, because sometimes I want to edit like the little beginning and intros out of those and make sure the audio isn't going to get me hit for a copyright. Yeah. Sometimes that's why I'm a little bit late. Because honestly, life is challenging and difficult and fun. And I like to highlight the fun on Fridays. So we keep
And he was
keep these
watching that
videos
clip
a
for
little
about
light.
6 hours.
Oh, yeah. I could watch that thing over and over and over again because it's just so cute. It's so cute. Jillian, thank you for the super chat. Recovering from migraine attack. I'm so sorry. Sipping a Jameson in Dublin to wet the shamrock. Happy St. Patty's Day. Happy St. Patty's Day to you as well, Jillian. And thank you for sharing. And I hope that hangover gets, and Joshua, we covered that one before. I hope that, not hangover. It's not a hangover. Why did I say hangover? Because it was St. Patty's. That was why I said hangover. I hope the migraines have subsided. So cheers to you. Happy St. Patty's Day. I hope that you are able to enjoy the rest of it. Can you and Runkle calibrate your audio to be close to the same volume? Let me double check what his has. Runkle, unmute briefly. Because I've got, I want to make sure that levels are where they are. Either way, we'll stabilize it when he gets back on. StreamYard is doing developments, and this coming week, apparently they're going to try and make a compromise like that's halfway through fully custom. So I'll be able to play with stuff, and God knows I really enjoy going down rabbit holes of figuring stuff out. Joe Doris, thank you. F cancer is right. Lost my husband and daughter to it. Prayers for all in treatment, and hooray and heart for all the survivors. Indeed. Don't let that disease beat you down, and don't let it take your character away from you. Don't let it happen. That's what you've got. You have your strength. You have your character. Don't let it take it from you. Scotty Cat Mom, I'd love your thoughts on Judge Schroeder. He drives me to drink. Can a judge be encouraged to hang up their robes? Judge Schroeder is, here's the thing. I watched the Rittenhouse trial, and I've been watching the Zachary Anderson trial. He's consistent. I have made the comment repeatedly. As long as a judge is consistent, a lawyer can navigate the consistent treatment of the litigants in the case. And Judge Schroeder is, I don't want to actually go out and say he's of the variety of paper tiger, but can tend to be that, where when you make a motion, make the motion. Argue very strongly for your position, and don't be afraid to argue too hard, because he will waffle a bit. I wouldn't say that he's had my head scratching on some of these opinions. I've been frustrated with some of the attorneys, and that I haven't thought that they have argued that I think I would, having observed him a little bit. But again, every case is different. Every judge is different. Every courtroom is different. And every jury that's hearing these cases is different. We're perceiving the Zachariah Anderson trial as outsiders looking in. We don't know what the jury is seeing from inside the courtroom. They might see it an entirely different way than we are. So I don't know. That's my opinion on Judge Schroeder. I tend to like his cordiality and friendliness from the bench. Chris and M96 robot lawyers, is the jury misbehaving? No, the jury is just fine. The jury is well behaved. They're back there hanging out. They're enjoying themselves. Hen House Bath Company, thank you. Celebrating St. Patty's Day with some champagne because I got a huge promotion at work today. Congrats, Hen House Bath Company. That's awesome. Promotions are amazing. They bring new challenges, more compensation, and, future learning opportunities. Let's put it that way. I love it. Congrats. Neurodivergent counselor, FNF, is even more welcome than usual. Tiny humans at work were all thrown off due to the time change, and there was a lot of floor sitting and practicing buffalo breathing. One, what is buffalo breathing? What is buffalo breathing? Is that a thing? Am I just missing out on what buffalo breathing is? I feel like I should know that. Buffalo respiratory therapy, durable medical equipment companies, blah, blah, blah. And that's different. That's a different one. Huh. Well, buffalo breathing, I'm going to say, is probably deep breaths in, deep breaths out. That's my speculation. But the time change has messed with everybody, especially the kiddos. Also the attorneys. I'm not a morning person. When someone deprives me of an hour in the morning, I'm less pleasant than I usually am. And I become more of a night owl than I usually am, which is also it can be frustrating. It can be frustrating. Stacey, the Judge Schroeder's long-winded. He likes to talk a lot. Some judges do. It is what it is. I find some of it to be endearing, some of it to be frustrating, and I find a compromise in between the two. He's consistent in his rulings, though. That's where I come down on it. The poll is too close. How close is the poll? Poll is close. My word. Come on, y'all, decide. What do you want? I don't know who you want. Don't know anything about the Zach Anderson case. It's complicated. Basically, the allegations are that Mr. Anderson, who was dating somebody, this person then goes and dates somebody else. That this was either known to him or not known to him or disclosed to him, and he put trackers on the person and did web searches for the trackers and how to order trackers. And the state brought a case for murder because this person disappeared. Now, the person disappeared. The girlfriend, Mr. Anderson's ex-girlfriend, this person's new girlfriend, or this person's girlfriend, said that after 12 hours of not hearing from him, she knew something was up, went to the house, saw blood in the house. Blood that was described by the DA said it looked like the room from The Shining. It did not. It looked like there was blood. I personally, having seen the photographs, it looked like there was a fight. I don't know. That's just my observations. Two other people converge on the house. One said they had a premonition something bad happened. Then the police get called. They show up. They find zero of the defendant's DNA on site. They then go and investigate. They find the defendant. They look at the back of the van. The van is a work van because the defendant's a contractor. There's no carpet in the van, but again, contractor, they don't find any blood in the van, but one of the officers says smells strongly of bleach. Anytime an officer puts in an affidavit smells strongly, I have massive red flags that fly up. There's just not a whole lot of evidence. There's a lot of really
marijuana
conduct. Yeah, I smell marijuana, or the defendant smelled strongly of alcohol. When they said smelled strongly of in an affidavit or a warrant, every attorney's antennae go up because it's a giant red flag. But in this case, there are antics that I'm seeing on both sides. One of the state's chief witnesses is a jailhouse snitch. And Mr. Snitch, I have seen snitches testify, and this one just all sorts of not credible. And I have no problem making that statement because the guy said that Zachariah Anderson was speaking in his sleep and giving like monologues in his sleep. And that's just not how that works. So we'll see. Right now, the defense is in their case. They plan to close, or they plan to rest on Monday. So I'm waiting for closing arguments before I actually do any summary on the case, because I want to see what both sides bring to the table. Brissy Girl, thank you very much. Almost in the hospital, still in the hospital after almost dying 2 weeks ago from multiple blood clots in my lungs, and my poor heart does not like me at the moment, but I'm recovering well. Brissy, I hope that your recovery does go well. I'm very sorry for that. Keep focused on you and your health, and I hope that your medical staff, which I am sure are very, very well trained, I hope they're doing their best to care for you. But cheers on a very rapid recovery indeed. Neurodivergent counselor, thank you. Buffalo breathing is a fun way to teach kids deep breathing and also shake out their wiggles and muscles. Oh, that's a good tactic. I like that one a lot. Jolly Rogers, thank you. That is a remarkably very, very, very generous super chat. Jolly Rogers says, I'd like Ian's take on the ice cream man trial in Tampa, where the state said the defendant made a Glock into a shotgun. Interesting.
I will have to follow up on that to have a look. Which day was that testimony?
Yeah, Jolly Rogers, if you wouldn't mind, Ian, your public email address, is that
Runklethebailey at gmail.com is the easiest one. It's on my
Yep, runkleofthebailey@gmail.com, lawandlumber@gmail.com. If you wouldn't mind, please that. I'm very curious about that day too. I'll take a look at that. Wow, a Glock into a shot. I wonder how it was argued. I wonder what they would have said. And I wonder what expert they had to testify to that. Because Jolly Rogers, thank you for that. Very much.
I'll try to get an answer for you for my Monday stream if you pop on then.
Yeah, and I'll try to jump into that. I'll try to jump in if Ian will have me. Speaking of Ian, the white circle is Ian. So he's packing.
With the nuclear pepper on it.
There's no nuclear pepper, buddy.
Are you not seeing an image of a pepper?
Nope. Just a little avatar. But
oh. Well then StreamYard is not doing StreamYard things. Who's StreamYard?
StreamYard does what StreamYard does. Jolly Rogers, I am officially remarkably intrigued. So I think you've caught the intrigue of Ian as well. So we'll take a look at that case. And I think you can expect an answer by Monday, because I don't know that I'm going to be able to go to sleep tonight without figuring out what that testimony is about. Mags Designs, thank you very much. Nobody is covering the ice cream man trial in Hillsborough County, Florida. Apparently now I have to do a deep dive on it, because that is, it's up for a second trial, I believe. Wasn't the first one a mistrial? This is the one where the guy was alleged to operate an ice cream truck. There was, I believe, allegations that he had been either beaten or assaulted, and then he went out in retaliation and shot 5 people. I will do my best deep dive. I will do my best deep dive on that and try to get you an answer, because that's really fascinating to me. Lori Ellis, thank you. Classic screwdriver, jasmine rice with sesame oil, beef, short ribs, Swiss chard. Had left hip replacement surgery on Wednesday. Hope you're recovering. Got home yesterday hurting, but enjoying the stream while trying to recover. You keep trying to recover. You keep focusing on that recovery. And I'm glad that you're here. Okay. So here's what we're doing. And John O'Brien. And yes, his YouTube is John Robine, but it's John O'Brien. That's John. John O'Brien is covering the trial. If he's covering it, I'll try to touch base with him between now and then. So we'll try to get cover on that. All right. We are 34 minutes in, which is the appropriate time for me to run the intro, because, well, that's how my brain functions. Jay Robine Law is covering it. Yes, it's a retrial after a 10 not guilty to. Oh, interesting. Interesting why the state would bring it if they knew those numbers. All right. All right. I'm fascinated.
It's because they think they can swing it around on the next.
I'm
on the next
wondering
round.
what they have that makes them think that.
Might just be that they think that if they run it differently, it's going to shake out differently. Because often the state gets to have a look at it and go, well, we did the following things that were mistakes. We don't think that the defense can step up their game. We don't think that they can do any better than they did before. But we can fix all of our oopses. And I mean, normally the defense doesn't have to provide their case to the prosecution in advance. And so you've got a bit of an advantage as the defense because the prosecution may not know what you're going to argue.
Yep.
Well, that goes away on a new trial because now they already know what you're going to argue. They've already heard it. And so, I mean, that might be their calculus. I don't know.
Could be. And here's a great place where I get to eat crow because Stephanie, you are 1000% right. I saw that email. I sent you an email with specific timestamps last week about the Ice Cream Man trial. Now, let me tell you how my Monday went. I have three high contest trials that are staggered, that are set to go in August, October, and then the last one is in January of next year. All three of them blew up over the weekend. So I have really not had very much opportunity to do much. I will take a look at your email and I'll take a look at any other summary people send me. And I will try to do a deep dive on that trial over the weekend and see if I can't do a catch up on that. But Stephanie, 100%, I eat crow on this one. That's my fault. Thank you for sending it to me. And thank you for being interested. And thank you for pushing the issue. I do really appreciate a lot of the feedback you guys give. And I do my very best to try and get to all of it when I can. All right, let me roll the intro. But before I do, I want some opinions on a certain thing that I saw that made me laugh. And it was Judge Manning out of Georgia. And she had a very interesting observation. Judge Manning out of Georgia does pre-trial, for those of you who like Law Talk with Mike. And she did an admonishment that I thought was curious on if you decide that you would like to speak over the court reporter or each other, this is what her possible punishment is.
Please remember, this is a dry record. All right? The court reporter can only take down one person at a time. So if I have to interrupt you, you get one warning. If I have to interrupt you a second time, or Madam Court Reporter has to take herself off mute, I will hold you in contempt and you will sit with the court reporter for one entire day and do takedown or transcribe a takedown that she has taken where people are talking over one another, and that will teach you to never, ever, ever speak over one another when the court reporter is trying to take it down. It will be up to Madam Court Reporter if she wants you to transcribe it or help her take it down. Go ahead, Ms. Gladden.
That is by far the best contempt warning I've ever seen. So I will force you to transcribe yourself one of these cases. So anyways, here's what we're going to do. Make sure I've got stuff started. K-Rab, legal advice plans to catch up on the ice cream trial. After the Anderson one ends, he'll go back and replay the previous days to catch up. I'll try to do the same over the weekend and see what I can't do to figure out what's going on. I like being able to cover this stuff. Unfortunately, job and like cases and clients makes it difficult to do that during the week. But with certain trials, I do try to make that a priority, and I'll continue to do so. I like learning. Learning's been fun. So let's roll the intro and get into it, and I'll end the poll and figure out where we're going from here. See you guys on the other side. Okay. When people said that the chat was divided They were not kidding. So here's the ultimate vote of the poll. So FTX YouTube influencer lawsuit, 27%. Speedrun updates, 24%. Robot lawyer sued, 24%. Michael Irvin defamation case, 23%. Wow. Wow. But the FTX YouTube influencer lawsuit wins out by one of my new favorite phrases Legal Vices taught me, wins out by a bee's dick. I didn't know that was a thing or a phrase that anyone ever used, but it's now one of the funniest things I've ever heard in my life. So, yeah. Anyways, let's go ahead and get caught up. I do like that Tia is saying hi to Nightbot. Nightbot appreciates the hello, I'm sure. Let's do this. Here we go. Present, share the screen, and we'll go through the beginning of the lawsuit. And this is what we're talking about. So class action was filed in the United States District Court for the Southern District of Florida, Miami Division. Edwin Garrison et al. On behalf of themselves and others similarly situated against Kevin Paffrath, Graham Stefan, Andre Jeek, Jaspreet Singh, Brian Jung, Jeremy Lefebvre. Did I pronounce that right, Ian? I think I did. Lefebvre?
That one can actually be pronounced multiple ways. It's often Lefevre.
Lefevre. Okay. Tom Nash, Ben Armstrong, Erica Kohlberg, and Creators Agency, LLC. So, class action complaint and demand for a jury trial. This was filed on March 15th. It's 73 pages. We're not going through all 73 because a lot of it is background that we already know. And if you would know if you've been following the channel at all, with some of the basic allegations of the downfall of FTX. But some of the allegations with regard to some of the defendants has been interesting to take a look at. Let me see if I can get the zoom it appropriately. There we go. Plaintiffs filed this complaint on behalf of themselves and others similarly situated United States and non-U.S. FTX customers against defendants, influencers who promoted, assisted in, and or actively participated in FTX Trading Ltd. For here and after FTX and West Realm Shires, FTX US, offer and sale of unregistered securities. Footnote. This is the only footnote that I'll be reading because I've pre-read this a little bit. The expert report of Paul Sibinek, lead case manager at Cypherblade, dated December 16th, is incorporated herein by reference and attached hereto as Exhibit A. This report was filed last year in the first class action in the country against various FTX defendants, including Sam Bankman-Fried, other FTX insiders, and celebrity brand ambassadors, which cases were consolidated and are pending before the Honorable K. Michael Moore, Garrison et al. Versus Bankman-Fried. I have always been curious when someone abbreviates their first name and they go by the initial first. What are you supposed to call them? I've always been curious about that.
Just call them by the letter.
Okay. That's not confusing at all.
I mean,
that's not confusing at all.
Point.
So, this is the lawsuit that was brought. Introduction. I love lawsuits to begin this way. The FTX disaster is the largest financial fraud in U.S. history. The former FTX CEO, Sam Bankman-Fried, otherwise SBF, is facing numerous criminal charges, and the new CEO, who helped wind down Enron, concluded that this fraud was worse than Enron. Billions of dollars have been stolen from investors across the globe. FTX was a centralized cryptocurrency platform which specialized in derivatives and leveraged products. It filed for bankruptcy protection in November 2022. If you had been following this channel, you would know a lot about that, and will be involved in federal bankruptcy proceedings for many years. Correct. There is no guarantee that any of the victims will be able to see any recovery from those proceedings. This action may be one of the only avenues for any of the victims to recover any of their damages. Plaintiffs bring this action against YouTube and social media financial influencers and promoters who shared financial advice and actively promoted FTX and its yield-bearing accounts to their millions of followers. This is where I jump in and say nothing that you hear on this channel will ever be financial advice. Never. Not once. I will never give you financial advice.
Except
Talk
that
to
don't invest in
professionals.
FTX now.
That I'm just going to say that's not even that's just practical advice.
Also, don't set your money on fire because they're the same thing.
You just money on fire doesn't. It smells bad. It's toxic. Don't do it. It's foolish. While we all loved that scene in Batman where Heath Ledger sets the money on fire, just don't do it. Just don't do it. But yeah, you will never hear me give any financial advice, and anyone that you see in the comments to my channels are bots that give financial advice. They show up every now and then, really annoying. They're probably gonna be the end of this video anyways. This is one of the reasons why I don't do this, for this reason. One, I'm not well versed in this. Yeah. Though FTX paid defense handsomely to push its brand and encourage their followers to invest, defendants did not disclose the nature and scope of their sponsorships and or endorsement deals, payments, and compensation, nor conduct adequate, if any, due diligence. We've talked about this before, and Ian, you were on stream when we did with the SEC video. You remember that one with Kim Kardashian?
Yep.
Uh-huh.
And a little tiny thing at the bottom that said, you know, this is a sponsored thing. Oh, right. Tiny, tiny, tiny font for like, you know, 0 seconds. Blink and you miss it.
And what did we say when we covered that one? When we said when we covered that one was, this is not going to be the first. It's not going to be the last. You're going to see more of these.
Although I also remember laughing a lot. So that was also part of it.
That's true. So, but this one here, this bothers me a bit. This sentence in this complaint: this action may be one of the only avenues for any victims to recover any of their damages. While this is very likely true, that the only way people are going to get money out of suing FTX or those affiliated are to go after the people who sponsored FTX, who have money because they didn't lose it in the crash of FTX. That
they
said,
have money left because they didn't invest it all in FTX.
Yeah, but that said, here's the problem with that type of argument.
That's
That
the kind of argument that.
Yeah, Ian, go ahead, finish.
Yeah, just because you were hurt and just because somebody else has money doesn't mean you're entitled to it from that person. You have to draw the connection. And I'm not seeing the connection drawn very heavily. I'm just seeing we are hurt. We would like some money, please. They have money. Where is the, you know, it's kind of the like, you know, first steal socks, you know, step profit, you know, or step question mark profit. We're hitting the question mark part. So yeah, I would like to see less question mark and more, here is why we should actually get money.
Yeah, and what I would also like to see is well, I can see why they would put the sentence in here, because when you're putting the sentence in here, you're basically telling the court and anyone reading this that, yes, we know that usually these lawsuits are aimed at the deep pockets, and that in a lot of circumstances, people would presume or assume would be FTX and Sam Bankman-Fried, but they don't have the money.
You don't tell the court, I am suing this person because they have pockets.
And that's the other side.
That's the dumb thing. Why are you doing the dumb thing?
That's the other part of this. That's why I don't like this sentence. It basically acknowledges that they are suing somebody who has a secondary, like they are acknowledging within the second page of their complaint that they're suing someone who has a secondary affiliation with FTX, and they want money from that person because they still have money to recover, while the recovery, you know, is really lodged against FTX and SPF. This type of argument might persuade a jury to say, well, these guys still have money. Granted, a lot of it probably not from FTX promotions because their channels are very successful. It just made me uncomfortable. It made me uncomfortable to read this. But then you go on a little bit, and a lot of this starts to make sense. With the rise to prominence of the internet and social media, a new multi-billion-dollar cottage industry of influencers has been created. Evidence has now been uncovered that reveals influencers played a major role in the FTX disaster. And in fact, FTX could not have arisen to such great heights without the massive impact of these influencers who
Man, I hate those guys. Influencers, what a bunch of bastards.
Yeah, well, I wouldn't call you an influencer.
I don't think I influence anybody, but it is, I guess, technically what people call.
You did win a Gundy.
Yeah, but did I influence anyone in the process, or did I just win something?
I don't know.
I don't know either.
You can influence for good and influence for bad. You don't have to influence to buy stuff. So, either way. But these particular influences, as alleged in this lawsuit, hyped the deceptive FTX platform for undisclosed payments ranging from tens of thousands to multi-million-dollar bribes. Now that's a fighting word right there. Footnote number 2. For example, the company.
How do I get a multi-million-dollar bribe?
Well, you, my dear elven friend, would never accept a multi-million-dollar bribe.
I mean, everybody theoretically has a price. I'm not convinced it's not multi-millions.
Like 500, 600, 700.
Yeah, I mean, there's a fair bit I might, hey, buy this shaving cream, 500 million. I could see it.
I mean, Ian would have to actually believe the product he was selling. I can't see Ian just doing that because someone's paying him to. I don't buy it.
I'm pretty awful. I mean, you've seen my product reviews where I'm like, hey, here's this product. They paid me to review it. It's not good. I've done a few of those. I don't know why people keep sending me products because I do honest reviews, but yeah, they occasionally do. So, yeah.
But yeah, so the footnote was, for example, the company Coinbound touts that we help crypto brands go viral using Web3's top influencers and influential marketing agency built for crypto. Yeah, that's not what you want to. I mean, virality is something, but when it's coming on the backs of money, proceeding with the lawsuit. Indeed, the most searched companies on the internet today are cryptocurrency brands. According to the NBA 2021-2022 Marketing and Partnerships Annual Report by sports sponsor United, the cryptocurrency industry has a high search volume during that year than the entire alcohol and beverages industry. Now, that was a surprise to me.
Do you really Google a beverage, though?
You don't.
Like, that's kind of where I'm looking at on that one. I'm just like, yeah, okay, I drink beverages, but I'm not typically going like, I'm going to Google this and see what's going on with, I mean, literally the only time I can remember Googling a beverage was earlier today. I did a search to see if it was like where that came from. And I was like, from the makers of Bud Light. Yep. Is it just the same product? Relabeled a little bit? I don't know.
Yep. And pulling one of these super chats out of order, Kristen says, Ian influences all on gun safety, user or not. Agreed. I will get behind that level of influence. Yeah, I'm okay with that. Paragraph 5. It is paramount to understand that the Florida state law claims asserted in this action, bold for emphasis, do not require reliance or deceit. The law merely requires the named plaintiffs and eventually the certified class to have suffered damages as a result of A, purchasing an unregistered security, and B, that was promoted by the defendants for their financial benefit and or the financial benefit of FTX. And this is the warning.
Theory.
All influencers.
But isn't this kind of bullshit? I mean, think about it. Like, we've had sponsorships forever. Can I sue Kanye if the shoes that he promotes are garbage?
Let me go back to A here. Damage is a result of A, purchasing an unregistered security. It comes down to that. And this goes back to the SEC video.
But what if, like, Joe Schmo, or what if, I don't know, pick a celebrity. Amber Heard decides to be the next face of the Pinto, which would
Of what?
really be the idea of the Pinto. They're bringing the Pinto back.
But the thing is, the Pinto is not an unregistered security.
No, but the Pinto is a death trap.
Yeah, but you're not. That's the thing. That wouldn't fall under the statute. It's not an unregistered security.
Yeah, it just seems weird that like everybody who is hired as a
Finishing the thought. Everyone who's hired is someone liable for this, blah, blah, blah. That's what Ian was going to say before his mic cut out because he's packing. No, but
yeah, I'm in my garage.
I know you are. My point here is that this is a security. And if you're talking about Florida specifically, go back to the crash of 2008. A lot of the mortgage-backed securities that were sold in Florida, a lot of the mortgage-backed securities that were out there causing a lot of what we saw before that bubble were sold in Florida. So it would make sense that the Florida legislature would react by saying, look, if you promote this thing that caused this harm, this unregistered security that has not been vetted through the SEC and has not gone through registration, that's a risk that you take on yourself. This isn't talking about like someone go and buy a thing like what you were saying. Like, this isn't me going out and saying like this car is great, go buy this car. This is me saying this financial instrument that has not been vetted, that has certain risks that I can't disclose to you. Go and buy that, and you're going to get tons of money. So I do see that. It
kind of seems like the same variety of thing because if I'm saying, hey, go buy this car, or, I've got different standards than most people, I guess, for, shilling something because I try things first. But typically, like a celebrity who's doing a car endorsement hasn't tried the car. Well, and they certainly haven't done like an engineering review of the car.
Well, so take that to the securities market. Like,
they probably wouldn't even know if the car is street legal or, doesn't contain a speed style bomb where it's going to blow up if you aren't running over none.
This is not a physical product. This is a financial instrument that is an investment that is supposed to grow. That's not going to have. It's not going to have. So, for example, if I buy a car today and I buy a car tomorrow, and it's the same make and model of that car, same year, make, model, right? I am expecting to get the exact same thing tomorrow as what my friend purchased yesterday versus a security, which is an investment, which goes up and down in value based on market forces. That's a very different thing. That's a very different animal.
Than, say, collectible plates where they market that it's going to go up and down in value or, and typically falsely. But I don't know. It's just the analogy here. I'm not buying that they're that different overall. In the sense of like, why is the face liable on this one?
Well, here's the thing, and maybe this will kind of like bypass some of the argument. Let me put it this way: the U.S. government and the U.S. law treats them as different.
Yeah, and that's fair. I'm just wondering about like whether the law makes sense as opposed to
that's a fair debate to have.
There's different aspects of like what is the law and is the law sane, and those are different questions. And I know frequently the answer to the second one is no. I'm just trying to find out if that's what's going on in this case. We're trying to play with ideas.
The point that is made, though, the point that is raised here at the outset in the complaint, and I agree that it should be raised really early on because there are people that are going to have this question, is the distinction between this being a security versus a lot of other things that we see people marketing. And at least let's table the moral argument. At least under U.S. law, securities are regulated differently than, for example, buying a car or buying a widget, something else that's sold over the counter. So, yeah. Onward in the lawsuit, the reality is that anyone around the world with a computer can now be a promoter. Many of these paid FTX influencers have since asked for forgiveness because many of these influencers rely mainly on their alleged independence and impartiality in attracting people to join their fan base. This action is brought to hold liable those influencers who specifically violated the law under these acts and will serve as precedent to warn and guide influencers in the future. That sentence is kind of tough because you have to read that in the context of what we're talking about selling. Ian is just having Wi-Fi issues out the wazoo because, well, Zora keeps attacking the internet Ethernet cable, so he can't connect. But either way,
it's true. Zora is. I was going to try to get the garage wired up for today, and it wasn't Zora this time. It was just that I couldn't get it strung through the armor. But it is still kind of her fault because I only need the armor because she's such a menace of a dog.
Mm-hmm.
We love her, but oh my god. So
well, yeah, but going back to what we were saying here is that, like, the thing that's weird about this one is many of these influencers rely mainly on their alleged independence and impartiality in attracting people to join their fan base. That is a very, very broad statement that I don't think is accurately portraying a lot of what people do out there when they're
many of these influencers are does that apply to any of the ones here?
Yeah, that's the question. And I agree with you. So, and then that last sentence, this action is brought to hold liable those influencers who specifically violated the law under these acts and will serve as precedent to warn and guide influencers in the future. That part, this is the one where, hey, we should punish them more harshly to that's
a criminal law argument.
That's
not a civil law argument.
That's pretty rough.
Yeah, that's a criminal law argument.
Yeah. So state and federal regulators have been required to quickly modify and adjust to all the changing sources of promoters and marketers. They have, and they've been doing okay, maybe not that great, but they've been trying. Starting with sponsors on radio, then television and motion pictures, and today to the wild west of the internet. The number of companies that specialize in promoting on social media have skyrocketed. According to
if the internet is the wild west, why can't I stream with guns?
Because YouTube.
That's what I'm saying.
I know. I get it.
I'm partially being a jerk here, or just, random. But at the same time, like the Wild West of the internet, come on. I hate that metaphor because it's so stupid. The internet wasn't the Wild West in the days where it was closest to the Wild West, and we're a long time past that. So now the internet is regulated to,
and I see people talking about my audio. My audio is lower because I'm being lazy and standing further away from my mic. But when I get closer, it should sound better. According to studies, those aged 18 to 34 are more likely to build an interest in an investment specifically from social media instead of traditional news websites. That's a sad effing study. Why are we looking at social media to actually determine what we are or are not investing in?
I mean, it's gotten so complicated to invest in anything. I can see it. I mean, it's tough. And I mean, don't trust me for your investments. I can guarantee you, I basically have this magic power where the instant I buy a stock, it goes down.
Well, and here's the other
really
part,
good.
Is the allegation that was read before, which is kind of bringing us back to the Kim Kardashian consent agreement, was that there was no disclosure they were being paid. If these influencers would have disclosed that they were being paid a certain amount of money, would that change your perception of the advice they were given or giving? I think for me it would. If I knew they were being paid money by especially a financial product or a security, that would change how I am viewing what they're telling me to invest in.
Yep, and that's fair. I mean, I literally titled one Uncle Sells Out because I was paid to vote about the I actually have no idea how much. I never actually looked into that. But pay me for talking about this antibiotic product. And I was like, and I only got into it because I got super curious about it. But like, yeah, I think it's fair to disclose. I just don't know if it's should properly be the law. I guess those are different animals.
Yeah,
but
that's fair.
If it is, it is.
Paragraphs 8 and 9 talk about the rising prevalence of these claims and how different circuits have entered opinions saying that people can be held liable for these actions. And then paragraph 10 gets us back into the facts. Literally overnight, plaintiffs lost their assets held in their YBAs on FTX's trading platform. And as FTX imploded,
they lost their assets?
Say that one more time, my friend.
Did you say they lost their asses? Because that's also accurate.
They did. They lost their asses and their assets. So in the months following FTX's filing, its founders, including SBF, were charged with numerous counts of fraud and money laundering, among other things. And as of the date of this filing, at least 3 of SBF's cohorts pled guilty to conspiracy and other criminal charges related to FTX's scheme to defraud its investors. And Sam Bankman-Fried is going to be the wrong end of the stick on the people that chose to plead out quickly. FTX's fraudulent scheme was designed to take advantage of investors from across the globe, including specifically in Florida, who sought out what was represented to be a safe platform to make their investments in the burgeoning cryptocurrency industry. The scheme resulted in FTX investors collectively sustaining billions of dollars in damages. Now we get to the parties, and I have some of these channels pulled up just so that you can see who we're talking about. Because a lot of times we don't really realize that. You know, we're talking about people and we're talking about channels. So I did take a look at these creators, and this is not to tell you to go and look or not look at them, but this is to put a face to what you're seeing here. This is all public information, so you guys can just take a look. Plaintiff Edward Garrison is a citizen and resident in the state of Oklahoma. He's a natural person over the age of 21 and is otherwise sui juris, which means that he is mentally and legally competent to serve as a defendant. That's what that means. It means that you are mentally competent and legally capable of being served and sued in a personal capacity. Plaintiff Garrison purchased an unregistered security from FTX in the form of a YBA and funded the account with a sufficient amount of crypto assets to earn interest on his holdings. Garrison did so after being exposed to some or all of defendants' misrepresentations and omissions regarding the FTX platform, as detailed in this complaint, and executed trades on the platform in reliance on those misrepresentations and omissions. As a result, Garrison has sustained damages for which defendants are liable. So that's laying out the plaintiff. All these plaintiffs, you're going to see the named plaintiffs. These are going to have the same set of facts. And in this case, the sui juris means the person is capable of suing, not just being sued, because he's the plaintiff, not the defendant. Also, oddly enough, recent developments in the law on named plaintiffs in class actions that get paid out more than other people in the class. That's another debate that we'll try to bring up for a different day, but that's been debated this week as well. Podolsky, another person with a similar story. Lindeen, another person, similar story. Chernovinsky, another story. Kavuri, another story. Gallant, another story. Nicole, another story. The defendants are digital creators who provide investor information and advice on an array of topics, including cryptocurrency generally and FTX on their YouTube channels. YouTube is the second largest search engine, which generates content that is accessible across the globe. The defendants, 1, all admittedly endorsed and promoted the sale of FTX YBAs, and 2, none of them disclosed in any of their YouTube or other social media posts that they were paid hundreds or of thousands and or millions of dollars by FTX and profited from the sale of FTX YBAs in clear violation of SEC, FTC, and various federal and state regulations. I would like to see where they get the millions part. I don't know that I've seen promotional details that would yield $1 million in a promotional dollar figure.
I mean, sometimes you see that for like major celebrities. I mean, hey, if there's millions of dollars I'm missing out on.
Yeah, YBA yield Well, here we go. So now we get to the people we're talking about. This is the name of the creators. And rather than walk through them, I'm going to do this. I'm going to share my screen and I'll show you who they are as far as their channels. And we'll go pretty quick. So you've got Meet Kevin, 1.87 million subs, 4,000 videos. He's a financial dad and financial analyst. You've got Graham Stefan, 4.25 million subscribers, real estate agent and investor, started working in real estate. Then you've got Andre Geek, 2.21 million subscribers. Then you've got Minority Mindset, 1.58 million subscribers. Brian Jung, 1.28 million subscribers. Jeremy Lefevre, 24,000 subscribers. That kind of hurts if he's in that.
Yeah, I was going to say, up until you said that guy's name, I was kind of thinking, well, the good news is that I'm safe.
Tom Nash, 284,000 subs. BitBoy Crypto, 1.45 million subs. Erica Kohlberg, 1.2 million subs. So those are the characters. Let me bring back the lawsuit so that we can get back to that. Those are the individuals that are sued. Kevin Paffrath, Graham Stefan, Andre Geek, Jaspreet Singh, Brian Jung, Jeremy Lefevre, Tom Nash, Ben Armstrong, Erica Kohlberg. Wait, one of those that I named wrong. And Jeremy Lefevre makes money. Oh, that's one of his channels, Jeremy Lefevre. So he has multiple channels. That's why that sub count was low. Jeremy Lefevre. Yeah, he has a second channel. And just so I'm not throwing the wrong person under the bus, I want to make sure I've got this right. I don't want to.
What kind of weirdo has two channels?
You. I think this is the same person. But just to be safe, here's what I'm going to do. Let me put his channel up just so I can show. Because I don't want people to think I put out the wrong channel. Financial education. My name is Jeremy Lefevre. I created Financial Education Channel. 720,000 subs. So same dude from what I can tell. But that's the channel that has the 700,000 subs. So those are named defendants. And then Creators Agency is a talent management firm that kind of promotes it as well. Jurisdiction and venue is the boring part. And then they go through some of the factual allegations. We've been through them 9 million times. We're not going to walk through them again. So we're going to go and fast forward. Apologies for the fast scroll to where we get to the allegations of the defendant's actual conduct. What I will note along the way is they spend a great deal of time in this case going through the securities allegations and the distinction between securities and all other products. They did it wisely. To take 5 to 10 pages of their complaint and walk through the difference between securities and actual products, I thought was good because it basically makes it very clear to the court, or it tries to make it clear to the court, this is different. Page 53 is where we get to the allegations.
Court, don't buy it.
And Runkle, are you in a place where you can talk for a minute?
I can talk.
Why don't you chat for a minute? Because I need to take a brief recess. Give people,
All right,
you have
Kat.
Monday. Why don't you walk them through your Monday streams and what you're doing on Monday?
Well, I was planning on discussing this, although briefly and largely from the angle of just the interesting aspects of creators getting in trouble for brand deals. There's another guy who also got in trouble with respect to he was selling a device that YouTube doesn't want me to talk about in a whole lot of detail. So let's just call it a naughty switch. And yeah, because YouTube does not like discussion of that kind of thing. And the naughty switch allows you to do bad things. So that's as far as we're going to get on that one. So because of that, he's facing a whole bunch of charges. The ATF wants to tear pieces off him and throw him to some other, so he's in a lot of trouble. He's trying to dig himself out of that hole. And so that's kind of interesting just to see, like, what do people think about this? Like, how does this compare with a lot of the stuff that we deal with in other scenarios? Because it's, I think it's a little novel that we're in this sort of wild world of where people can go to jail or lose their entire fortunes over stuff they do online, and stuff in particular that they promote, which I don't know if we would apply the same standards if we were talking about physical goods or the like. So that's, I think, an interesting question. I was going to talk about the moose thing because, as much as it's not a Canadian moose, all moose are honorarily Canadian. Oh,
we can leave the moose thing off tonight. Well, I think we'll preview it tonight.
We can talk about the moose thing. I got no problems with that. It's just kind of funny. There's also, I was going to cover the lawsuit over the wings. Did you hear about the boneless wings lawsuit?
I did. I didn't get to add that to the docket. I saw it was kind of wild though.
Yeah, there's also some interesting stuff going on in the background on that one. So I pulled a bit of I pulled some of the court documents, and there's a bit more of a story to this guy. So we can talk about that one. I think that one's kind of fun. Yeah, don't hold back on anything on my account. We will have plenty to talk about on Monday. And worst case scenario, we can hang out and I'm going to do a shooting competition in between now and then. So that'll be something to talk about. Although my wife is going away on a trip. So she's got my GoPro. So I will have to, I guess I'll have to charge my phone and see if there's people who are willing to film me on that. And then I can show some of my, now I'll caution people, if you are used to watching, various sort of badasses, I am not that. I am a guy who is learning and, struggling along. So I feel like I've had a pretty good day if I don't disqualify and my pants stay up. That's pretty much my standard.
I will say that Ian has walked into the majority of the innuendo this evening. It has not been me that has done it. Pants staying up, naughty switch. And it's because he's distracted. And I appreciate the fact that he's walking into these innuendos openly.
So that you don't have to.
Yes, it works. It works fine.
Well, it's going to be an interesting, it's going to be fun, I think. So we'll see how that, I'll have a range report to see how I did. I suspect it's going to be badly, but that's part of the fun of doing these things.
And
you
Pam,
can't get good at something without sucking at it a lot.
Yeah. Pam did walk into a refreshing part of the conversation, a new part of the conversation, and Trufflehound is refreshed that Ian is setting off the chat today. I am as well. For those of you who are wondering who this figure is beneath me, this is Ian Runkle of the Bailey. He recently won an award in Texas for the Gundy's Awards for Breakout Content Creator of the Year, and he's a good friend of mine, Canadian firearms lawyer Canadian criminal defense lawyer in Edmonton that does a lot of educational content on firearms law. If you have not checked out his channel, please do. Like I said, he has recently opened up a slot on Mondays where he does a Monday. I'm going to call it Monday Fun Day. I don't care what you call it. It's Monday Fun Day to me.
Fair enough. I'm still figuring out a name. So the first time I called it Cure for the Mondays, because Mondays can kind of suck. And
Yeah.
it's nice if we can make them suck a little bit less. That's kind of my hope. And but yeah, Monday Fun Days isn't a bad way to go at all. So I may steal that.
Pam, this is a fair point. It's the best bromance on YouTube. It's awesome. Okay, so defendants.
I'm not going to complain about that. It's 100%. I think it's accurate.
And
so.
Fun. the amount of teasing that goes, it's fun. It's great. I love it.
Oh yeah, it's you got to have a sense of humor about life. Otherwise, life will. Life can suck at times. You got to be able to laugh at it.
It really, really can. And having that sense of humor is critical to it, which is why we do the Friday Night Frenzy and the Monday Fun Days. See?
There we go.
All right. So going on to the actual conduct engaged in by these defendants, because this is the part that I was most curious about in the lawsuit. So from its inception, cryptocurrency has been fueled by illicit activity, and the crypto sector continues to be rife with crime, frauds, and scams. They cite a bunch of third-party reports. I think this is kind of overselling. I get there are risks, but I also see why they have to take this position.
There's lots of people who do illegal stuff with cryptocurrency, but it doesn't mean that cryptocurrency is inherently shit.
Exactly.
Yeah.
Exactly. And that's the thing. It doesn't mean that all of the market is shady. This is making it sound like the entire market is shady.
Yeah, and you gotta think about, are you playing things too hard? Because there's a real possibility that they get somebody on the jury who let's look at your worst case scenario. Somebody who was an early Bitcoin investor and is retired now.
Yeah.
And is probably feeling pretty good about Bitcoin. And so if you come in and is like, Bitcoin is a dark and evil force in the universe, that person's going to hate your face. And that's not good. You got to think about, I suspect they're going to try to keep anybody involved, like who's ever even bought a single Satoshi, off the jury. But I don't know. It's we'll have to see.
Yep. So everyday consumers have fallen victim to various cryptocurrency related scams. Yep. And there are plenty of scams that are out there. Like I said, it bears repeating. You will never see anyone advertising or promoting crypto in the chat that is me. It is a fake. Do not, I will not, and will never promote any financial investment or give financial advice on this channel. There's a long history of consumer loss associated with centralized exchanges, FTX being the latest. All the above mentioned problems with cryptocurrency are well known, and one of the biggest reasons why consumers are hesitant to purchase or use cryptocurrency. This is the point they were trying to make. According to Pew Research, 16% of Americans have invested in cryptocurrency, while another 71% are not invested. Although they have heard at least a little about cryptocurrency. For those in the latter group, concerns about fraud and scams are likely playing a role in their resistance to crypto investing. Fair. Crypto firms like FTX turned to celebrity and social media endorsers to position itself as the safe option among cryptocurrency exchanges. The FTX advertising campaign is particularly pernicious because it implicitly acknowledges cryptocurrency's problems while holding FTX out as the safe place to invest in crypto. This is where I think they're going to get in trouble, which were proven untrue, as FTX turned out to be a house of cards that misappropriated customer assets. FTX paid endorser program was clearly designed to use the positive reputation associated with specific YouTube and other social network influencers to convince consumers that FTX was a safe place to buy and sell cryptocurrency. As Mr. Sebenek explains, FTX's brand ambassadors had a critical role in portraying FTX as being safe and compliant. FTX not only deployed such well-known celebrities such as Stephen Curry, Kevin O'Leary as brand ambassadors, but also engaged in aggressive global digital marketing, particularly through influencer crypto marketing on YouTube and other social networks. Crypto marketing is the execution of marketing and advertising efforts with the goal of raising awareness, acquiring users, or driving growth for a cryptocurrency or blockchain related product. Popular crypto marketing strategies include influencer marketing, community growth, social media management, and grassroots digital marketing, and tout great results and valuable case studies specifically with promoting cryptocurrency. This is great. Here we go. Social media influencers are, this is the definition, by the way, individuals who have amassed a large following on platforms such as Instagram, YouTube, and TikTok, and use their influence to promote products, services, and ideas. Social media influencers are characterized by a huge number of highly loyal and engaged social media followers who share a rapport with their fans and are perceived as everyday people who are experts in their niches. I feel attacked.
I don't. I'm not perceived as everyday people. I'm barely perceived as people.
I don't tell you I'll buy anything or go anywhere and do anything. I do promote ideas. That idea being talk to each other and use common sense. But this is, yeah. Okay.
Yeah, no, I don't
also disagree with a lot of people that follow the channel. I like disagreement. I don't like telling everyone to get in line with something. I don't know.
Yeah, no, it's at the end of the day, we've all got different opinions, right?
Mm-hmm. Yeah. Runkle is an elf, not people.
See?
So, yep. Unlike mainstream celebrities, influencers don't shroud their lives in an air of mystery and present themselves as real-life consumers who share authentic and valuable information with their followers. They create content that resonates with their followers, often by sharing their personal experiences, lifestyle choices, and preferences. By doing so, they establish a sense of authenticity and relatability with their audience, which can be incredibly compelling. This is also the problem with selling shit. I mean, I don't mean to say it that way, but there's a part of this that's very true, which is also why I'm not comfortable selling stuff.
Yeah, I mean,
I don't want to buy someone something because I say I like it.
I mean, I will tell people that I like stuff if I like stuff. I've had people go, "Hey, is this an ad?" And I'm like, "No, I just like this." Because like the one hot sauce that I've been just consuming a lot of, I'm not being paid. Actually, I shouldn't say I'm not being paid by them, because they did reach out after they saw me talking about how much I liked it and are sending me another hot sauce. But I just like the product, and yeah, it's just tasty. Like,
also not sponsored.
Yeah, it's not sponsored. It was just that they reached out and were like, "Hey, can we send you a hot sauce?" And my answer to that is always yes. And my wife's answer to that is, "Do you really need another hot sauce?" To which my answer is yes, but
yes. And Wild About Law, you influenced me to buy a poopsie. I did no such thing. No such thing. If you bought a poopsie, it was because you saw how traumatized that made me. No. Do I have merch? Yes, it's terrible. I don't promote it because it's terrible. And that's just
I might start selling some of my leatherwork stuff, but not. I think most of it I'm probably just going to. I'm kind of thinking maybe doing giveaways on for like the Extra Life fundraiser. So it's just like, if you donate X much, you get into, I'll give stuff away. So I don't know. That's kind of my thinking.
Jane, I don't know how I'm supposed to respond to this. So I'm not supposed to get a screaming goat. Personally, in my life, that gives me pleasure. If you want one, get one. If you don't. Screaming goats, in my experience, relieve stress, and they are great to tease your friends who have children that you can teach to press the buttons. That's more torture than anything else. So it's not really Yeah. Witness. Yep. It's not good enough yet. It's not. I'm trying. So we'll figure that out. Influencer marketing thus involves collaborating with a social media influencer to increase brand visibility and strengthen the brand's reputation. When executed correctly, it helps win more customers from target audiences and earn more revenue. What differentiates influencer marketing from other types of celebrity marketing is that it is perceived as more authentic and trustworthy because owing to an influencer's rapport with their fan, their recommendations aren't dismissed as fake and sponsored endorsements. Instead, their followers often swear by the recommendations made by their favorite influencer because the audience trusts them. They are more likely to take their recommendations, which can lead to increased sales for the products they promote. I'm going to put another poll in the chat. I'm very curious about this one. And this is not meant to throw shade one direction or the other. Have any of you ever bought something because it was endorsed by an influencer or endorsed by a social media personality? How about that? And then I'm going to say, what's the best way of saying the answer? You know what? I'm going to leave it at that. Yes. No. And then I'm going to put one more option. They pointed, I researched. We're going to ask that question. I'm curious about that because I don't know that I have. Well, that's actually, I don't know if that's true. There's a lot of woodworking specialists out there, a lot of people that are practicing woodworkers who make a lot of beautiful stuff. And I watch their videos to get ideas. Ian, you can add yourself to the stream, my friend.
I was going to say, I don't know if I should use this power.
You can use the power. Ian is co-host, by the way. I don't know that I've ever bought something because it was sold to me by an influencer, but I have. There are woodworkers I trust that use certain products where when they describe what the product does, and they are very, for example, Mark Spagnolo, the guy's, his YouTube channel is Wood Whisperer. Dude's been making YouTube content since the beginning of YouTube. For example, one of his videos talking about the use of finishes goes back like 10 to 12 years. And that video is still one of the most popular videos that I still go back to when I'm trying to figure out how I want to finish a certain thing I'm making. And I will buy things or I will use that to educate my research on how to buy something. But I don't think I've ever said to someone, hey, I'm sponsored by this, buy it, and bought it.
I mean, that's not usually how it works. It's that you look into something and you decide that it's something you want.
Yeah.
So,
and this is a good point. Cloudy, I bought EDB Stanley coffee mug. I bought the 40-ounce Stanley because I didn't know the thing existed until I saw it. And then I saw it. I was like, this is fantastic. And I use it every day. But
I like this one. The Alex Murdoch trial influenced me into buying lots of guns to leave in random places.
Sure.
Don't do that.
Maybe. Don't
That's
do that.
not good gun safety.
Lindsay, good comment here. Rob, Emily made you buy cups and me to sign up for NordVPN. I don't, well, one, I want to clarify here, Lindsay. Emily didn't force you. She said that this is something that I can give you as a associated deal. She also didn't make me buy the Stanley cups. I bought those by myself and I didn't even use her discount code. Sorry, Emily, if you watch this. I didn't use your discount code.
Uh-oh. She's going to chase you down.
I didn't know that she had one when I bought it, but it was really cool when she was talking about it. So I don't know. I'm very curious about that, though. I don't think about that a lot. So while influencer digital marketing is more expensive than other types of paid media, studies done on the subject show that the majority of marketing teams have found the return on investment, the ROI, on influencer marketing to be higher than that of other forms of online growth tactics. I would agree with that. I can see that that would be effective. According to a recent study, influencer marketing delivers an ROI of $6.5 for every $1 spent. That's
That's
impressive.
interesting.
That's impressive. What's the footnote? Footnote 95. What is that study? The rise of influence marketing, Shane Barker. Okay. This is far higher than the ROI of other forms of digital marketing. Digital content creators also can more precisely target their marketing efforts by using highly sophisticated analytic tools such as Google Analytics to measure their site's traffic, where it's coming from, and who is visiting their sites. That is something that a lot of people don't realize. YouTube backend analytics, Google Analytics is, I've never seen anything like it. What you can see. Now, I don't know how to use any of that data, but I can imagine in the hands of someone that's like a specialized marketing professional, they probably could. So, interesting. Is that Zora or Potter?
That is Zora. My wife just stepped out, and Zora's got opinions like, hey, where's she?
Yeah.
So that is Zora. She's unhappy that that my wife is not here.
So, as such, digital marketing through social media is extremely effective at influencing consumer decisions. According to a survey from the National Association of Professional Financial Advisors, NAPFA, more than 1/4 of Gen Zers learn about finance from social media. That is kind of scary. The survey results also show that more than 1/3 of Americans under 65 receive their financial advice from social media. Also scary. When it comes to where they are getting financial advice, YouTube is I think they're supposed to be one of the most popular platforms for Gen Z and millennials to discuss financial planning and investment in cryptocurrency. More than 60% of the respondents who received their information online say they have acted on that advice. Holy crap.
Wow. But
60%.
I'm going to step out for a little bit. I've got a very sad pupper who probably...
That's fine. You take care of that. I got this.
All right. Be right back, or be back in a bit.
Yep. 60%. That is a wild statistic. So essentially, when it comes to financial advice, 63% are saying they're getting that advice from YouTube. 71% for millennials, and 60% of the respondents who receive that information. So if they go to YouTube to get the advice, say they've acted on that advice. That's a large percentage. Wow. It's kind of scary. YouTube, which allows for long-form video content, which can exist in perpetuity, which is why lawyers on YouTube tend to be pretty cautious about positions we take, because it does exist in perpetuity. I want to make sure the information I'm giving you is accurate. It's one of the most effective social media channels for targeting cryptocurrency audiences and has found its way into the daily routine of millions of cryptocurrency enthusiasts worldwide. For those of you who are not aware, who have not looked at the comment section of some of the videos, you will see my face pop up in some of these comments. The name associated with it is not me. It's oftentimes some chain of string of numbers saying invest here, or you will see these other scams. I reiterate, I will never try to sell or advise you in one way or the other when it comes to this stuff. Talk to a professional in that field. But yeah, I can see how people are targeting other people like this. Many of the most famous finance and money social media influencers collaborated with FTX, working under the umbrella of Defendant Creators Agency, a talent management for digital creators. This is now a warning for those agencies. Creators Agency touts its expansive reach and claiming to have reached millions, including 2.94 billion YouTube views, 27 million YouTube subscribers. Though not all creative agency clients endorsed FTX, many of the talent it manages, including certain of the defendants, netted hundreds of thousands, if not millions of dollars from signed contracts procured and or facilitated by the agency. That's a lot. That's a lot. VC, they're all ghost accounts. Every one of them. The accounts get reported by a lot of you guys, and I appreciate you for doing so because they're not me. But people go and do sketchy stuff. For their part, the defendants, Kevin Paffrath, Graham Stefan, Tom Nash, who prior to FTX's collapse promoted FTX as a safe investment to their legions of followers, have now scrubbed their YouTube channels of all video clips endorsing FTX and praising Sam Bankman-Fried. That's just smart. That's just smart. In their place, the YouTube influencers have substituted mea culpas and apology videos acknowledging their significant role in promoting FTX and causing billions of dollars in investor losses. That's the part right there. Like that's the tough part. Because this is a great one here. And this is kind of my view. I bought camera gear based on what photographers I follow recommend and use, but I always read reviews of everything first. Yes, the other thing about camera gear is you're often not buying it. You're buying it to use it. And there's a difference in purchasing something that has an effective use. For example, a chisel, a saw, a freaking like a jumper or something you see online, or camera gear, something that you see that you're going to use, and buying it based on their experience in using it versus buying something that is supposed to make you money. I personally view those differently. I think they're in different categories. And even with buying a product I'm going to use, I look at the reviews. I don't trust it. I look at the reviews. Buying something that's supposed to generate wealth, I am hyper skeptical of. That's just me. Yeah. Julia, like the mini chainsaw I just said, I was the most tempting. Yeah, there's stuff that gets purchased for that. But for example, defendant Kevin Poffroth, who upon information belief received $2,500 every time he mentioned FTX in one of his videos, posted a video to his Meet Kevin YouTube channel with over 1.86 million subscribers on November 22nd, 2022, in which he states, yes, I used to be sponsored by FTX. I think that is a disgrace and it's a scar and it sucks. If I could go back, I would change it because people got hurt because of that. I feel so terribly about that. People got hurt because FTX and it's a disgrace. Well, now we see the other part of the internet. And this is where people always say, don't apologize. One, $2,500 every time you mention FTX in a video. That's a pretty good payday. I don't think I'd ever be comfortable with it ever, but that's not me. That's their choice. Similarly, defendant Graham Stephan had built a loyal fan base on YouTube by sharing financial advice. After aggressively promoting FTX, he posted a video titled My Response to FTX to his YouTube channel with over 4.2 million subs on November 28, 2022, in which he states FTX US has been a recurring sponsor here on the channel since spring of this year. I can't even begin to share how devastated and sorry I am. I made the mistake of working with a platform who operates with an industry that does not already have proper consumer protections in place. Oh, you didn't run this past legal, did you? On the most basic level, I made the mistake of assuming that Sam Bankman-Fried's image had anything to do with his credibility. I fell into his trap of effective altruism. It's this part. It's that part. That's the one sentence. I made the mistake of working with a platform who operates within an industry that does not already have proper consumer protections in place. That to me kind of indicates like that I wouldn't have advocated as saying it was a wise thing to put out there, because that indicates that they knew that this was not the best way of going about it. Defendant Tom Nash, who apparently posted a video following FTX's bankruptcy in which he claimed to only have worked with FTX US, which he falsely represented the video to be 100% operational. Nothing is going on with FTX US, has since taken down that video. Oh, shit. So, oh, shit. So his video basically after the bankruptcy said that, oh, this is a problem. Claimed only worked at the FTX US, which he falsely represented in the video, was at that point in time 100% operational. Nothing is going on with the FTX US. Yeah, I can see that being a problem. And I can see why they put the lawsuit. Yep. That's tough. That's tough. Because that one, that right there, the reason why I'm saying that is knowingly or should have known to be misleading. After the bankruptcy, FTX US was the entity that filed bankruptcy. And that video being posted after the bankruptcy filing is bankruptcy filing takes place. That company is under the protection of bankruptcy law. It is no longer operational until a bankruptcy judge says so. That company is frozen. Operations will only continue to the extent that the bankruptcy plan reorganizes and allows operations to continue. And for that video to come out after the bankruptcy filing to suggest to everyone that is following him that it's fine and nothing is going on is the same thing as Sam Bankman-Fried saying it's fine. The difference is that Sam Bankman-Fried saying that beforehand is not good. Sam Bankman-Fried saying that afterwards and saying, that's like Sam Bankman-Fried coming out after the bankruptcy filing. It's like, it's fine. Leave your money in here. Don't try to come after it, or, you'll get 100% of your money back. That's a problem. I have a problem with that video, if that's true. It's an allegation. I don't know if it's true, but if it's true. Endorsements by the defendants are even more dangerous because of their broad public reach. People are more likely to watch YouTube than network television. Micro celebrities and social media influencers thus can have outsized influence on their audience, particularly those that espouse financial advice. I do not give financial advice for this damn reason. FTX capitalized on this dynamic and sponsored several of those content creators, particularly on YouTube. This is making me uncomfortable, guys. We're going to get through the rest of it. We will, I promise you. Other organizations and individuals with presumably more to gain did find red flags at FTX and turned down FTX and or Sam Bankman-Fried's money. The nonprofits, Our World Data and MITRE, declined offered gifts of $7.5 million and $485,000 respectively from the FTX Future Fund due to undisclosed red flags. Footnote 104. 104 is essentially an article citing the declined sponsorship. In addition, CME Group CEO Terry Duffy allegedly told SBF that he was an absolute fraud upon having an initial conversation with him. I think that video is on the internet. Finally, after FTX's implosion, the Financial Times reported that FTX held talks with Taylor Swift to sponsor the singer's tour for more than $100 million. While the article does not detail the reasons why Swift declined the FTX offer, it does include the following quote from a person close to negotiations. I'm not going to even buy that for a second because anyone that says they're close to negotiations isn't. Based upon information that has been released by FTX's new CEO, John Ray, as part of the company's bankruptcy filing, anyone who bothered to spend 20 minutes reviewing FTX's operations pre-collapse would have identified significant red flags. I don't know. That's overstating this. This was covered up pretty well in the documentation. There were red flags, but people continued to invest. I don't know that it would have been easily ascertainable by these third parties. That's where I'm having a difficulty. There's a distinction between the video that goes out and says after FTX filed bankruptcy, everything's fine, don't worry, to, hey, let me take a look at what FTX is doing. FTX gives you some literature and you say, cool, I can sign on to this. That's a distinction. So I don't know about that one. And this cites back to his testimony, Mr. Ray's testimony. The findings of Mr. Ray's pleading, we've gone through those before. All the corporate formalities that was lacking. It's hard to imagine that anyone who has done business with FTX, including paid endorsers, would not have personally witnessed one or more of the deficiencies identified by Mr. Ray. All FTX endorsers have extensive business dealings beyond FTX and surely would be able to identify business practices that are unusually problematic. I disagree with that. I disagree with that. Now, here's the caveat. Here's the caveat. I don't give financial advice because, and I also don't give legal advice on this channel. I give legal advice to the clients that hire me for their specific case because everyone's case is unique and the facts are unique to them. And the advice I would give would vary from client to client based on their specific circumstances. Financial advice has always been weird to me. For example, I have always found it odd that real estate agents, personal argument here, I think their licensure, their testing, their standards need to be updated. I don't like that they don't have to disclose certain things. I don't like that they can be on both sides of a deal. I don't understand how that works personally. But then again, conflict rules are so ingrained into my background and education that I can't disassociate from those. That said, is a real estate agent who's talking about a house, are they supposed to be trained as an inspector? Are they supposed to know whether a house is up to code or not? Or can they rely on the inspector that gives them the report? Influencers. Can they rely on information provided to them by third parties? And is that reliance reasonable for their position? I don't know. This is a curious argument for me. It's a very curious argument. We'll see how it plays out. I have trouble pegging liability to these influencers for simply going out there based on materials they were provided. If, for example, they researched the materials they were provided and saying, this product, from what I have reviewed, looks fine. If they never looked at the materials, that's a different story. But they can rely on the reports that are given to them by a company. For example, when you go and buy a stock, you have SEC disclosures and you have third parties who have gone in and reviewed the inner workings of a company, and you can rely on that information when you go and buy a stock, and the risk is passed along to you, the consumer. I guess a lot of this also goes back to the fact that these were unregistered securities, and it's where does the risk fall? Where do we place the risk? Am I muted, Kelly GB? You are saying I'm muted. I don't think I'm muted. I can hear me. I think I can hear me. So I have a problem with this position a little bit. I wonder how they're going to argue it. And I imagine they're going to have to flush this out in discovery. So it's the discovery part of this. What are they going to find in discovery? What did these people know before they went and gave videos? And yeah, grab my passport. I see, as lawyers, do you get experts? Yes, we do. And we rely on those. To an extent, we rely on them for the facts that we're trying to relay. As far as the law, we rely on ourselves. We have to. Real estate agents rely on the inspectors that they hire, and they're allowed to because they're not experts. This is interesting because if they're passing themselves off as experts in the field, then can they pass that expertise off to some third party? I don't think so. Each one of these cases, that's why I don't think this class action, I don't know about naming all these defendants in one class action. I think that each one of these cases has to be viewed individually, separately. And Unless you're going to lump them all in on the liability that they didn't disclose that they were being paid. But from the outset, some of these people said they were being sponsored and paid. This is interesting. I have questions on this. I imagine we're going to see a motion to dismiss based on impermissive joinder. The defendants are going to try and break this up. They don't want to be one class of defendants. Then you'll see motion to dismiss for failure to state a claim, arguing that despite all of the articulation that they didn't actually state a claim against these defendants. So we're going to have to see where this goes, because this is going to have a ripple effect. Again, though, choosing to go and promote an unregistered security is fascinating. And Sarika, that is why I made the caveat of yes, they are saying they're financial advisors. Some of them are, but some of them that I have looked, some of those channels we've passed through don't say that. And I think that you're right and wrong here. That's why I said that I would anticipate seeing a motion to dismiss based on impermissive joinder. They're going to try and break this up, because I think each one of these are going to be very, very interesting to view individually for what these creators said. Because remember, when you had the previous suits, they were suing Kim Kardashian, right? SEC Kim Kardashian. That was against her for a very specific set of tweets that, or Instagram posts that she put out. And they said that those things by that one person were misleading because A, B, C, D, E. Right now, you have them lumping all of these creators into a class and saying, all of you guys did the same thing. But did they act on the same knowledge? Did they act with the same background information? Did they act with the same level of recklessness or disregard? Each one of their intents in relaying information is going to be a point of controversy. And you can't really say that the whole class of influencers were acting as the same brain. It's not how that worked. Despite popular euphemisms about how influencers don't really have one or they share them, I'm going to be very curious here. I don't know how much traction this lawsuit's going to get. And that makes sense why they brought that first few paragraphs in the lawsuit as intensely as they did, and saying, look, there's no other pockets to go after. They want the judge, they want the court, they want the court of public opinion to view this as being the only avenue that these injured parties can get recovery. And that brings back the question, is that the proper way of getting recovery? No. Is the poll gone? What did it say? Let's see. Let's end that poll and see what we've got. Have any of you bought a product because it was endorsed by a social media personality? 43% of you said no. 29% of you said that they pointed, I researched, and 26% of you said yes. And that's after about 1,000 votes. So look, we've had pretty divided discussion here tonight. I think that's interesting. I find this fascinating. We're going to see where it goes. So yes, FTX used, and going to this paragraph, FTX's explanation for using social media influencers, micro celebrities in their own right, and stars like Tom Brady and supermodel Gisele Bündchen was no secret. We're newcomers to the scene, said then FTX president Ben Harrison, referring to crypto services landscape in the US. The company needs to familiarize customer with its technology, customer service, and offerings while competing with incumbents like Coinbase Global or Kraken. We know that we had to embark on some kind of mass branding, advertising, sponsorship type work in order to be able to do that. But where does the liability rest? Even with that even with that sentence, where does the liability fall? For that matter, do you go after the NFL? That's a question. The Miami Heat allowed FTX to rebrand and put their name all over the basketball arena. The NFL during the Super Bowl allowed FTX to run ads. Do you go after the NFL? Is that what we're going to see next? Because the NFL allowed them to use the platform. They should have known better than to allow them to use the platform. That's a deep pocket. Why isn't the NFL being sued? I don't know. Where does this argument end? How slippery is this slope that we're going down? Stitch of Whimsy. Tom Brady and Giselle are subject to a separate lawsuit. There are other lawsuits against the other individuals, Stephen Curry, Tom Brady, etc. In other words, FTX entities needed influencers like defendants to continue funneling investors into the FTX Ponzi scheme and to promote substantially assist in the sale of the YBAs, which are unregistered securities. Then they define the class: global class, nationwide class, Florida subclass. And then they go ahead and define the numerosity, these are preconditions to be named a class. Commonality, again, this is all class actions have to include these different things. Typicality regarding the claims, adequacy of representation, that the attorneys that are bringing this suit can represent all individuals in the class. Then there are disclosures that have to be made under the federal rules. Superiority of these claims as opposed to others. Then other disclosure requirements. Count 1. Violation of the Florida statute section 517.07, the Florida Securities and Investor Protection Act. Plaintiffs individually and on behalf of the classes. Section 517.071 provides that it is unlawful and a violation for any person to sell or offer to sell a security within the state of Florida unless the security is exempt under Florida statute 517051, is sold in a transaction exempt under separate statute 517061, is a federally covered security or is registered pursuant to 517. Section 517.211 extends liability to any director, officer, partner, or agent of or for the seller. That's the part there. Agent for the seller. If the director, officer, partner, or agent has personally participated or aiding in making the sale, is jointly and severally liable to the purchaser in an action for rescission if the purchaser still owns the security, or for damages if the purchaser has sold the securities. So they're going on this argument here that the agent, which is the acting agent for the seller, has personally participated or aided in making this sale, and saying they're liable for either rescission, give me my money back, or damages if the sale has occurred. So the YBAs sold and offered for the sale to the plaintiff and class members were not exempt from registration. They were not a federally covered security. They were not registered with the Office of Financial Regulations, and they were not sold in a transaction exempt under 516.061. The FTX entities sold and offered to sell unregistered YBAs to plaintiffs and the members of the class. Then they've got Florida deceptive and unfair trade practices. Which essentially allows a cause of action that is premised on the goal of the act, which is to protect the consuming public from those who engage in unfair methods of competition or unconscionable, deceptive, or unfair acts or practices in the conduct of any trade or commerce. So they say that they're consumers. And it says the defendant's unfair and deceptive practices as described herein were consumer-oriented and are objectively materially likely to mislead and have materially misled consumers acting reasonably in the circumstances. So that first one is their stronger argument of the two. This one, the second one, requires a certain element of reliance and the materiality of the false statement. Called a Ponzi scheme. going on. Then you've got conspiracy, which ties them all together and says that they knew that this was going to happen, or one of them did, and they're going to tie them all together for it. And then count 4, declaratory judgment. What are they asking for? Declaratory judgment. What are you asking for here? Order declaring the YBAs were securities. Oh, they want to say that they were securities and they did not work as represented. Okay, that makes sense. So they want certification of the class. They want actual direct and compensatory damages, awarding restitution and disgorgement, which is give us the money that they earned. Awarding declaratory relief is permitted by law or equity, including declaring the defendant's practices that set forth herein to be unlawful. And awarding injunctive relief is permitted by law or equity, including enjoining the defendants from continuing those unlawful practices as set forth herein, and directing the defendants to identify with court supervision victims of their conduct and pay them all money they are required to pay. Interesting argument there. They have to point out everyone that follows them. That actually kind of sounds interesting to me. It's kind of saying, hey, give us your sub list so that we can go out and find more plaintiffs. Have you or a loved one that you know been a victim of a cryptocurrency scam? Please call this number right now, 1-800. Please call cryptocurrency scam. Yeah, plaintiffs' lawyers are out and about, by the way, on this particular lawsuit. They are all over the place and they are growing in this space. So that is the FTX YouTube lawsuit. Kind of start to finish. You got to see the channels. We see what they're going after. And while we're on the topic, before we transition to another topic, let's go ahead and make sure that we cover the rest of the FTX stuff so that we're not playing catch up. And that will then cover some of the things that we thought were the quick bits, the quick little stories. Present the screen. Edge tab. There we go. There we go. Okay. FTX transferred. So this is from Reuters reporting. March 16th, 2023. FTX transferred $2.2 billion to Sam Bankman-Fried via related entities, new managers say. On March 26th, bankrupt cryptocurrency exchange FTX made transfers of about $2.2 billion to the company founder, Sam Bankman-Fried, through related entities, the company's new management said. Overall, more than $3.2 billion was transferred through payments and loans to company founders and key employees, FTX said in a statement on Wednesday. Do the math, folks. $3.2 billion to company founders, $2.2 billion of that went to Sam Bankman-Fried. These payments were made chiefly from Alameda Research Hedge Fund, FTX said, adding that it made these disclosures by filing schedules and statements of financial affairs with the bankruptcy court. They filed like 20 different sets. No, scratch that. 50 or 60 different sets of statements and schedules. I am not pulling those up. I read through as many of them as my brain could function reading through. We're going through the consolidated report. The crypto exchange said the transfers did not include over $240 million spent to purchase luxury property in the Bahamas, political and charitable donations made directly by the FTX debtors, and substantial transfers to non-debtor units in the Bahamas and other jurisdictions. A lawyer for Bankman-Fried, interjecting my own word, wisely, continuing on with the story, declined to comment. FTX filed for bankruptcy protection in November, saying it was unable to completely repay customers who had deposited funds on the exchange. FTX's new CEO, John Ray, has said his top priority was recovering assets to repay customers. Prosecutors have charged Bankman-Fried. We've talked about that one before. He doesn't denies any wrongdoing. So, want to see if I've got the breakdown. Let me see. SBF, Ellison, money received, bankruptcy schedules. Because the allocation between the two of them were kind of interesting. Come on, please. Let's find the story that we need because it was reported. And I want to make sure I've got the right numbers. And where are we? Come on. Why is this? I tell you what, man. I look at these articles. Oh, here we go. Oh, every now and then you just forget what I'm doing. So, reporting from where are we? Cryptopolitan. Look, the numbers are accurate. They're based on the actual filings. Sam Bankman-Fried, FTX and Alameda's research top brass apparently received $3.2 billion in payments and loans from FTX-linked entities, according to financial statements filed in the bankruptcy court. They're tracking about $8.9 billion in missing funds. We've talked about that one before. And here's the relevant part. According to the filing, Sam Bankman-Fried, co-founder of FTX and CEO of Alameda Research, received roughly $2.2 billion, while Nishad Singh, Gary Wang, Ryan Salome, and John Samuel Trabucco and Caroline Ellison received. So this one first. Nishad Singh received $587 million. Gary Wang, $246 million. Ryan Salome, $87 million. John Samuel Trabucco, $25 million. And Caroline Ellison, $6 million. Wow. Like, look at the disparity. Sam Bankman-Fried, $2.2 billion. Singh, $500 million. Salome, $250 million. Trabucco, $87 million. Salome, $87 million. Trabucco, $25 million. And Caroline Ellison, $6 million. Oh, you wonder why they might have turned on him. Oh, you wonder why they might have gone state's evidence. Oh, so bad. Yep. So that's the bankruptcy disclosure document. That's a shitload of money that they received. They were paid out. I don't know why Caroline Ellison only got $6 million. It makes sense as to why she is cooperating with the government. Just saying, kind of weird, but it is what it is. So let's catch up on, and then we've got FTX. There was one more. Oh, FTX TikTok. Yes. Of course, we learned this week that FTX, while in bankruptcy protection, has done just fine. But what they have not done is they have not disabled their corporate TikTok account. Yeah. Generally speaking, if you're getting hit with lawsuits left, right, and center over commercial dealings and influencer accounts, disabling the crypto account or the TikTok account that has all the advertisements might be the way to do it. So let's see if there's any of these that are worth watching.
Great.
It's going to play.
The best ever, right? But he's not thinking about being the best. He wants to be
you're not playing? Is it already playing for you guys? Because it's not playing for me.
Couldn't be better. I could do better. He can do better.
He wants to practice better.
Ouch. That's better.
That was better.
Recover better.
Night, Tom.
He even wants to eat better.
Can I take your order?
Either way,
Steak.
Tom Brady
Steak.
is out there.
I'll have that
giving all the-
parsley.
It's playing for you. Okay,
Yeah.
good. It's playing for
First
you
he
guys.
leaves,
Wonderful.
now he's getting even better.
But better doesn't stop there. He wants to be a better teammate,
I love that guy.
a better friend,
I love that guy.
even a better enemy.
I hate that I love that guy.
You think I could get better?
Oh, you could get way better.
Save room for dessert?
Where's dessert?
So you know he's going to invest in it too.
FTX, that's the crypto app,
Let's
right?
see if we got
Now
any.
it's for
There's
all kinds of
Tom.
investing.
There's Tom Brady making
better.
some money. Good for you, Tom. Stephen Curry. Let's see if we got this one. Congratulations to the Warriors, entrepreneurs. Got some of this stuff. Let's see if we've got the Tom Brady lighting fire to something. Crypto Bahamas. All of these influencers that are out there promoting. It's amazing. Oh, this is the one that got. This is the one that got all the promotion. So we'll play this for real quick.
Probably just getting another dentist. This guy. First, even if you wanted to come back, we wouldn't take you.
Yes, you would.
Yeah, we
would.
You're right, we would. What's up?
I'm getting into crypto with FTX. You in?
I believe I'm in, but still hate you.
Understood.
Even on the phone, that guy sounds handsome. Probably just getting another dentist. This guy. First, even if you wanted to come back, we wouldn't take you.
Yes, you would.
Yeah, we would.
You're right, we would. What's up?
I'm getting into crypto with FTX. You in?
I believe I'm in, but still hate you.
Understood.
Even on the phone, that guy sounds handsome. Probably just getting to the dentist. This guy. First, even if you wanted to come back, we wouldn't take you.
Yes, you would.
Yeah, we would.
You're right, we would. What's up?
I'm getting into crypto with FTX. You in?
I believe I'm in, but still hate you.
Understood.
Even on the phone, that guy sounds handsome. Probably just getting to the dentist. This guy. First, even if you wanted to come back.
Trader. So, generally speaking, if you are going to, oh, Trevor Lawrence did too. That's unfortunate. So that was a funny little aside. Save us. I'm sorry. Sorry, there's no saving. Things on autoplay. That's my bad. I couldn't make it stop. I'd step away for a second. So we'll take it down. That's Tom Brady. Theranos' Twitter is still live. Is that true? The audio for me is bothering me because I want to figure out why I can't hear what's going on. Okay, that's working. I don't know why anything else is. Okay, either way. So. All right, so let's catch up on Super Chats. Then I'll swoop, and then we'll get to the next story. So let's do that. So here we go. Mellow Logic, try Baby Goat Yoga. They're wander around while people doing poses. I've seen it. I want to try it. I think it's fun. I'm totally down to try that. I have to find a place that does it. Thank you, Mellow Logic. That Sarah chick, thank you. Yay, I made it to your live. It's been a busy week in the insurance world here in California, having a much needed rum and Coke. Cheers, Sarah. Hope you're having fun. J. Michael, RN. I go by J. Michael, the whole thing. I like that. I feel like if you're going to do that, that's the way you go. I think that's the least confusing way I've heard that said. Susan Faria, thank you very much. 2 ounces of vodka tastes better than kashaka. 1/2 lime and 4 teaspoons of sugar. Gently crushed sugar. Oh, okay. Gently crushed sugar and lime together to get the juice out. Add ice and vodka, stir and enjoy. Very much Brazilian. Okay. So 2 ounces of vodka, 1/2 lime, 4 teaspoons sugar. Gently crush the sugar and the lime together to get the juice out. Add the ice and vodka, stir and enjoy. Done. Next drink for the evening. Chris Mullen, thank you. The prosecution has no murder weapon for the ice cream murders. They've introduced 3 or 4 options: 2 shotguns, rifle, modified Glock 45. It's wild. Holy crap, really? Those are very different weapons. Like very, very different weapons that do very different things. I'm curious. Travel Hound, thank you. Hello and welcome to the Lent Halftime Show, sponsored by Guinness. To all our Catholic friends out there, you're welcome. Sincerely, St. Patrick. Travel Hound, I trust that was read with the zeal that you hoped and wished that I would read that with. Lindsay, thank you. Ian influences me to play with Midjourney to troll him about Destructo Dog. I am curious. K-Rap, thank you. Coffeezilla did a video on this. He made the same point about it being a security. He has an interview with one of the defendants who said, basically, you decided to invest and you were an adult. Not my problem. Yes, to a point. I want to go back and see, because someone said that which one of the guests it was. So who in the chat real quick, who did Coffeezilla interview? It was Kevin. And I want to see if it's in any of the allegations. Allegations, page 53 of the complaint. Let's scroll and find out what we're talking about. That's the token. These are just bullshit allegations, craziness. What the heck is going on? Where is the many influencers, blah, blah, blah. There's the channels. Organizations did not agree. That's the Swift stuff. The Swifties. You're not going to fuck with the Swifties. Tom Brady, Gisele Bundchen. Absolute fraud. Meet Kevin, I think, was who he interviewed. And that was the one who said, used to be sponsored. It's a disgrace, it's a scar, it sucks. I don't know. That might help him, his position. Yeah, Meet Kevin. The video he released on November 22nd said, yes, I used to be sponsored by FTX. I think it's a disgrace and it's a scar and it sucks. If I could go back, I would change it because people got hurt because of that. I feel so terribly about that. People got hurt because of FTX and it's a disgrace. I wonder how that's going to work out when they find out how much he knew and how much he had told people about his expertise and whether they should or should not follow it. That's different. And the fact that it's an unregistered security, you can't really, if you are promoting unregistered financial products, you can't really, based on how Florida statute is written, simply say, you're an adult, make your own decision. That's the whole point of the registered versus unregistered. So I am curious to see how that plays out. Truffle Hound, thank you. The buy a Scottish title scam is sad. There is a separate court, the Court of Lord Lyon in Edinburgh, that handles all titles, arms, and heraldry. Interesting. Brian Miller, thank you. Sent Twitter DM. Would like your take on that video if you have a chance. I will pull that up in a moment. It's Murdoch related, so I will pull that up when I get a chance. Thank you, Brian. Elizabeth Webster, thank you, from Santa Rosa, California. Thank you. Hope you're having a good time out in California and hope the rain is not bothering you too much. Krista Peterson, snowed in and I couldn't take our kid and team to state archery tourney today. Well, I'm sad. Archery tournament sounds fun. I'm sorry you couldn't take them. Thankful for Friday Night Frenzy for a pick-me-up. Check out the North Dakota roadmap to feel better about your weather. Almost 80 inches of snow this winter. My freaking word. Rebecca, thank you. Rob gave me an excuse to buy more craft stuff. Hey, you never need an excuse to buy more craft stuff. Elizabeth Webster, thank you. Sorry I was late. I love my corned beef and cabbage, coffee, and Jameson here. Thank you. Thank you. Jillian, thank you very much. Ian, I love the tie. Looking good. He's going to come back. He's tending to the puppers. Lindsay, I wonder what they're constituting as the financial advice because I look to YouTube for explanations of like the mechanics of how to go about investing, but not what to invest in. Everyone is different, Lindsay, and I'm very, very curious there. I'm very curious about how people go about investing. That was why I asked the question I did in the chat. I'm curious about how that takes place. Crazy Cat Queen, driving from Colorado to Florida, watching on my cell because hotel internet is shite, and now I'm only halfway and sick in a hotel. Thank goodness for Rob, Ian, and Sparkle Farts. Crazy Cat Queen, I hope the travel goes better tomorrow. I'm sorry you're not feeling well. We're going to get this stuff going in a better direction real quick. XCDA, I was influenced to buy pupusas, but didn't because I wasn't able to find a place to get them. That's unfortunate. They're phenomenal food. Adrian Angevine, FYI, CoffeeZilla did a video on this topic, and no one would give an interview except Meet Kevin, and I think he should not have given that interview. Based on what I'm seeing, I would probably be inclined to agree with you. So we'll see. Karen S., was the filing just about FTX? If so, would there be separate numbers for Ellison and Alameda? The filing itself, no, it wouldn't. So the filing itself in the bankruptcy court was all of the related entities. Let me see if I can show you guys what it actually looks like, because that actually might help explain why when I'm talking about, hey, I couldn't pull up the bankruptcy filing to show you. Let me tell you why. So here's what the docket looks like for the FTX bankruptcy and the liquidation case. So here's the docket, right? Let's go to the actual docket. Case link, quick links, case navigation. Give me the docket numbers. And let's go ahead and show 200 of these items at a single time. Applications for compensation, compensation, compensation. So when we start to get the schedules, all compensation, mind you, this bankruptcy was filed in November and we're at docket number like in the thousands. That's ridiculous. So schedules 1083. This is the schedules and statements filed, statement of financial affairs for FTX Lending Incorporated, filed March 15th. Okay, so remember that number, 1083. Scroll down, schedules for all of the entities, every single one, all of them, every one of them. Still going. Don't mean to make you dizzy, but we're still scrolling. Yes. Still going. My earlier estimates were terrible. Yep. So we're over 100 filings. Still schedules, motion for relief from stay. Oh, look at this. I didn't see that earlier. He wants insurers for FTX to advance his defense costs. I haven't seen this. Should we look at it? Do we look at it? He wants his insurance. He wants FTX insurance companies to pay his defense costs. Oh. Okay, I have to look at it briefly. I'm going to look at it briefly. Yes, briefly. We're going to look at it briefly. I'm too curious. That's some set of balls. Are you kidding me? What? How did I not see this? So in the bankruptcy court for the District of Delaware, motion of Sam Bankman-Fried for relief from the automatic stay let me out of the bankruptcy proceedings so that I can ask insurers to advance and or reimburse defense costs and fees under the directors and officers insurance policies. Oh, you son of a bitch. Wow. Let me read. Let's read a little bit. Oh, I don't know how to think about all of this. We're going to figure this out on the fly. Sam Bankman-Fried, by and through undersigned counsel, moves the court pursuant to 362D1 of Title 11, yada, yada, for entry of an order, substantially the form attached here too, gives a draft order, finding that the automatic stay does not apply, lifting or modifying the stay to allow the advancement or reimbursement to Mr. Bankman-Fried of defense, settlement, or other defense costs covered by the following insurance policies. Realm Insurance, excess claims made, directors, officers, liability insurance. That's the Beasley excess policy. And then, so the three policies. Mr. Bankman-Fried is a named defendant, otherwise involved in criminal, regulatory, civil, and other actions, proceedings that have resulted in and can be expected to continue to result in significant unreimbursed legal fees. No shit. The defendants, debtors have denied any indemnification or advancement to Mr. Bankman-Fried and have refused even to provide him with basic information about his indemnification and advancement rights. Okay. When you are alleged to have defrauded the company that you represent, does that company then have the obligation to defend you in criminal actions or criminal cases brought against you? That's the question. That's essentially what we're talking about here. Mr. Bankman-Fried is covered by insurance policies designed to protect against exactly this circumstance. Mr. Bankman-Fried provided notice of the pending matters to various insurers In response, Realm, the primary carrier of the DNO, director and officer policies at issue in the motion, reserved rights with respect to the ability to evaluate coverage and indicated that Bankman-Fried must seek a modification of the stay, either through a stipulation with the debtors or by way of a motion before any covered payments can be made. Get permission of the bankruptcy court. That's what it says. Mr. Bankman-Fried asked the debtor's counsel to stipulate to relief from stay consistent with the language in the policies, which A, provides priority of payment to individual insureds of the unindemnified loss, like Mr. Bankman-Fried, and B, waives objections to the requested relief. The debtors declined, necessitating this motion. Jurisdiction, venue, yada yada, don't want to hear that. The policies. As a former director and officer of debtor West Realm Shires, and certain of its subsidiaries, Mr. Bankman-Fried is an insured under the director and officer's policies. The Realm Directors Officer policy provides primary directors and officers coverage in the amount of $5 million. The Beasley policy provides excess coverage in addition amount of $5 million. The Beasley excess policy follows form to the Realm policy. The DNO policy provides Side A coverage for, among other things, defense costs incurred in defending against covered claims. Quote, the insurer shall pay on behalf of the insured persons all loss for which the insured persons are not indemnified by the company, and which the insured persons become legally obligated to pay or on account of any claim first made against them during the policy period. Basically, if you get sued while in acting the course of your duties as a director of officer, we come in and pay your defense. Loss includes the amounts insureds become legally obligated to pay on account of a claim made against them, including but not limited to damages, including punitive, exemplary, and multiple damages, judgments, any award of prejudgment and post-judgment interest with respect to covered damages. Okay, so damages. You do something, you can essentially ask the insurance company to indemnify you for damages that are being claimed because you acted as a director and caused someone harm. Okay. Reasonable fees, don't need the definition. The policies contractually require the company and its subsidiaries to indemnify and advance expenses to the individual insureds. So got to pay the attorney's fees, fair. The DNO policies provide, however, that if a company refuses or fails within 60 days to request indemnity or advance covered losses, the company is unable to indemnify or advance covered loss due to financial impairment, the insurer shall pay any covered loss. Okay, so pay the losses, fair. Ian, how much ketchup do you need? Have you heard any of what I'm talking about?
No.
I found a spicy case, or a spicy thingy.
Spicy thingy.
Let me.
Rob's got a spicy thingy.
No, I'm sorry. I'm excited. Hang on. So I was trying to show people the docket. I was trying to show people the docket for Mr. Bankman-Fried. And in doing so, I stumbled across something that was hidden amidst about 200 schedules that were filed. And it was this: the motion of Mr. Samuel Bankman-Fried for relief from the automatic stay to the extent applicable to permit the insurers of FTX, the company in bankruptcy, to reimburse defense costs and fees under directors and officers insurance policies.
That's interesting.
So he wants the company, through its insurance company, to cover his criminal defense case that is based in part on him defrauding people using the company and defrauding the company.
I mean, I could see why he'd want that.
So can I, but I think that we need someone else to help us think about this. Hi, Kurt.
Hello.
How
are you?
Those are some exceptional eyebrows.
Thank you.
They're amazing.
Also,
oh God. Of course you did. Unicorn farts. Okay. Yeah.
Oh,
okay.
I'm not a fan of sours.
Neither am I. I just had to buy this based on the brand alone. So we'll see if it's any good.
Okay.
I bought some chili lime drink as well, and it's so awful. It doesn't taste like anything other than just like soda water. And I'm going, oh, It's like soda water mixed with sadness.
This is so weird to me. Kurt, did you catch any of what I was saying?
No, unfortunately, I was not feeling great earlier, so I took a nap, and I'm awake now.
Well, good. So this is the Amber Heard defense, but different. Because
I've heard about this. I've heard about this.
Insurance policy specifically covered. It's specifically covered in like defamation.
Mm-hmm.
This is an insurance policy for the company, and Mr. Bankman-Fried is asking to use this insurance policy to pay his criminal defense while the company is in bankruptcy. I don't know. This is a stretch.
Yeah.
So, okay. So a lot of this is standard language when an insurance company does not.
Also, these policies are, by their nature, typically civil.
Correct.
And he's being tried criminally. Or is this for his civil cases related to this?
Let's go back, because he finds himself the defendant, because when he makes the argument here, Mr. Bankman-Fried has been named as a defendant or is otherwise involved in criminal, regulatory, civil, and other actions. So he kind of like shotgun approach.
I'm not sure that makes sense in the first instance, to be honest.
None of this makes sense.
So a lot of this is standard language you put in a lawsuit when you're trying to get the insurance company to cover and they don't want to. The notice requirements, they didn't respond. The coverage layouts and identification of what the coverage is. This is interesting to me though, because where was it? Let's look at this. Costs, derivative demands. So it covers derivative suits.
Yeah, like look at this language. If loss due and owed by the insurer, that's what is loss? Loss is money. Sam Bankman-Fried's problems are not just money.
Yeah,
I don't know there's no insurer who could pay for, I'll go to jail for you. That's not a thing in the United States. Maybe other countries, but not in the United States.
Indemnifier advanced the covered loss.
Yeah.
Due to
the insurer cannot indemnify your criminality. That is just not a thing.
I mean, they can potentially cover like criminal charges or like the your lawyer's fees.
Yeah.
But that's if the company gets sued or if you get improperly sued as a director and it's a corporate liability case. This is very much different. This is basically an allegation, or the criminal charges are that not just he defrauded people, he defrauded the company and used the company as a vehicle to commit the fraud. So I don't know. Here are the pending claims. Let's talk about this. Oh shit, this is kind of interesting. The pending claims. Currently, there are multiple criminal, regulatory, and insolvency-related and civil actions that are pending against and otherwise involve Mr. Bankman-Fried. Criminal proceedings, U.S. versus
I wouldn't have expected that from such a stand-up gentleman.
I don't think that's a thing. I have
There's been zero news
right off the bat.
There's been zero news on any of this. None of it. Yeah. SEC versus Bankman-Fried, CFTC versus Bankman-Fried, Texas Securities Board, Bankman-Fried. Then you've got insolvency-related proceedings. This is funny. This part is really effing funny. This case, and where's the adversary proceeding? This case. No, that's the Voyager. This one. This case, the Block 5 versus Emergent Fidelity. No, that's New Jersey. This case here, what he's asking for defense in, the debtor is suing him personally to recover money that the debtor paid to him. His argument is let this insurance company defend me against the company. Like,
no.
I like your answer, Kurt. It was concise. It was to the point. It was very.
Sometimes I know the answer. Sometimes it's just like, just want to raise your hand. Like, I know the answer to this one. Let's go.
No. Okay. All right. Civil actions. It's a lot of civil actions.
This one wasn't hard.
This is,
and I don't know. I don't know like an E&O or a D&O policy in this world that covers for fraud.
That's the thing.
That's also not a thing that I've ever heard of.
Yeah, no, this one right here. Exactly. S. Moore. Exactly. His actions are willful.
Yeah.
This is defrauding the company.
In fact, I think such a policy would be void on public policy grounds. Just in the sense of like you can't offer like insurance for if you decide to murder somebody.
Right.
This actually, people ask about how can I have you on retainer as a criminal defense lawyer. I'm actually limited. Like, I can't take your money now on the basis of I might commit a murder in future. Let me give you some money now. Law Society says no to that. Even to things like, hey, I'm dealing drugs. I know I'll get caught at some point. Can I leave some money with you? It's like, nope. Can't do it. Yeah, you got to get caught first. Then I can take your money.
This is wild. So Mr. Bankman-Fried, through counsel, submitted notice letters to various carriers, insurance, including notices to Realm under their policy. In subsequent correspondence, Realm reserved its rights regarding the impact of the bankruptcy filing.
I like the footnote. That's very cute.
Realm has not issued any formal coverage position, but in discussions through counsel has expressed its view that at least several of the pending claims are unlikely to implicate coverage. Yeah.
You think Realm has expressed some skepticism that they might have some liability for some of this?
No.
They've expressed some views that perhaps maybe this isn't our problem.
Are you kidding me? The balls to file this motion. This is a joke.
I don't
siding
think he
for the insurance
realizes
company without breaking a sweat. Something is wrong.
This is so uncomfortable. Like, I didn't expect to even see this motion. This is desperation.
I think he doesn't really realize just that. Like, I think this guy's got some problems in really assessing his situation. I suspect he's got people who tell him that he's the hero of this story, and he probably believes that.
Well, so here's the last pushback. Here's one little bit of pushback I'm gonna give. So a relief from stay. So right now, one of these insurance companies is saying we can't do anything because it's in bankruptcy. So we can't even do an assessment under our policy to determine if you qualify because it's in bankruptcy. So one of the insurance companies has said, you need to get an order that says, let us actually determine whether there's coverage or not before we can do anything. And at the end of the day, that's what this motion actually amounts to. It's saying, hey, let me make this limited claim to the insurance company to ask them to cover it. And if they don't, maybe let me sue them to try and force coverage. That's what this is asking for. And the bankruptcy court might grant this to say, hey, we're not going to resolve the dispute between you and the bankruptcy, you and the insurance company, because we're not in position to do that. But a state court judge, they could, because they interpret insurance coverage all the time. And this might get laughed at a state court, but the bankruptcy court might say, I want no piece of this. You go out and you do that on your side. So I'm just laughing at the underlying premise that he's asking for this coverage.
I mean, the guy has never been short of courage to ask for bold things.
Audacity. We call that audacity.
Why does he need money? Word. Just pay his criminal defense lawyer and some FTT. He should have some of that floating around.
Oh my God. The magical token that is no longer a token. I mean,
it has nowhere to go but up.
It's Because it doesn't have a floor. We have found the floor.
It is infinite. It is infinite percentage potential. So what a deal.
My word. I did not see that coming. That wasn't on my bingo card tonight. And thank you to the chat and to everyone for allowing me that little digression of 15 minutes on the longest docket that I've ever set out for a Friday Night Frenzy. Why did I do that to myself? And another sidetrack that I promised I would show Ian, and Kurt, you'll enjoy this too. I was driving back from Loudoun County Courthouse this week, and in driving back, I found a building. On the side of the building, it had this logo that was emblazoned XCal. Ian, have you ever heard of what XCal is?
I don't think so.
It's wonderful. So the logo on the building was XCal, and about XCal, it is a gym. Shooting sports and fitness. It's a gym for shooters.
I've never heard of such a thing, and I want to move back to Virginia immediately just to go to this.
Yeah, I'm like, do they have a drop-in?
Dude,
Yeah.
can I fly back out there and can we go to the gym together?
We can
working
go to
on my
the gym
workout
together.
routine.
We can do that, but I'm going to do a swoop and we'll go into the proper of XCal.
I mean, I've heard of country clubs, but this is a whole new thing.
This is a new thing. This is a shooting complex that has multiple facilities, and it has shooting sports and fitness as a part of their program, where you can do competitions. There's basic training, there's steel shooting competitions, there's permit application requirements, there's basics, pistol basics, there's tactical emergency casualty care that's offered training, advanced pistol work, youth rifle league, women only pistol basics. I thought that was awesome because I know that there's an amount of discomfort in training when you have mixed gender classes. And then there's not just the shooting stuff. They have fitness classes.
Oh my God.
Different training regimens, functional fitness, cycling, sambo, yoga, flow.
Shut up and take my money.
And then not only that,
They've got a spa.
There's a spa.
Oh.
I want to go.
There's a spa. They have
we get a couples massage. Yes, Rob, we're gonna get a couples massage. You and I.
Massages. They have different Swedish massages. They've got sleep massages, sports. This place, I was like, is this a thing? What is this magical place? And then, like,
I don't care.
Then they have.
Can I write this off as a business
Instagram
expense?
Page. And side note, anyone that is a ex-cow, hey, I live not far away from you. I know I just did like a whole lawsuit on not being influencers and not doing all that stuff. I will not promote your brand, but I will gladly use that membership.
I'll promote your brand.
Different. Oh my gosh. Like all of the fun stuff. Literally, it's a gym for shooters.
I like it.
Like, so that was my little tidbit that I found on the way home from court the other day. Thought it was worth sharing. Just to make everyone insanely jealous that exists now. I didn't know that existed or was a thing.
The only thing wrong with it is that it's in Virginia.
No, that's not wrong. That's fine. That just gives you a reason to come visit, and Kurt a reason to come visit, and us a reason to go and like have fun experiences.
We could totally get our chat to sponsor this field trip. This is great.
This is
we're gonna get
fantastic.
ourselves a shoot. We're gonna get ourselves some shooting. We'll do a HIT class, HITT. We'll do a couples massage. Wow, this is great.
It is honestly. It's the training part. It's the fact they do all of that training, the fact that they couple it with fitness and well-being, and like that is what a lot of these things need. proper training and facilities to actually do this stuff the right way. Like, holy crap.
I'm having some thoughts relating to like recent like TikTok and social media trends with like women filming men who are staring at them or something, and how that might play in this environment with the fact it's a gun workout club. That raises whole kinds of issues there.
Like I post a video or a camera of me shooting, and like there's someone who walks by and looks at me shooting. Oh my gosh. Yeah, that's that's wild. No filming at the gym. No filming at the range. Well, we can't put it on YouTube. They have said that. That's
I'm sure if we ask really nicely, they'll make a cover.
You can put already videoed stuff. You just can't do live streams of shooting.
Do live. Yep. So that was my little aside. Now, Kurt, I know that you have taken a look at a certain case.
Yes.
And it has to do with the use of a very peculiar murder weapon.
Yes. The Minnesota man trying to be more Minnesotan than a Florida man trying to be Floridian.
So I've got an article that's up, and maybe we should walk through the article, and why don't you give us it
gets dark in its details.
It does get dark in the details. What was the best article that you found on it? Because I think the broad one here, I found a pretty good one that's kind of broad in the details. It doesn't get into the nitty gritty. But yeah, I'm getting yelled at. I have to swoop. Yep. Change of topic. Swoop. Sorry, Kurt.
I have to do my joke. I'm sorry because it's the gun jib thing. Is that a gun in your pocket, or are you happy to see me?
Oh my God, Kurt. There's that.
I mean, it can be both.
That is appropriate. And it's hilarious at the same damn time. Is that a gun in the pocket, or are you just happy to see me at the gym?
It can be both.
It can be. That deserves its own swoop to go into the Minnesota story. All right. Minnesota story. Swoop. So yeah, did you know that moose antlers could be used as a lethal weapon?
I mean, yes, moose do it all the time.
So this article, granted, it's TwoFab. It's one of these other media consolidation companies. I'm not giving a whole lot of credence to the article, but it does give a generally not like rated R version of the fact here, which can get kind of dark. Minnesota man confessed to using moose antler to murder a sex offender. Yep. No part of this story is actually as pleasant as it honestly,
it kind of gets worse from there.
It gets worse from here. It really does. So police say that Levi Axtell believed Lawrence Scully, a 77-year-old who was charged with sexual assault of a 6-year-old girl in 1979, was attempting to, quote, groom his daughter.
Yeah. And
when you
look into the details, at least based on the news reports, it seems like his suspicions are not fully without some sort of merit. This person has been previously charged with crimes relating to children.
Yep.
And there is evidence that supports the proposition the person was interacting with his daughter in ways that would be concerning. So that's it's dark because the person was doing some potentially very nefarious things, and
I mean, the thing is, he turned himself in. So there's a part of this where it's like, you did the bad thing and you shouldn't have done the bad thing. I don't know that I can morally or personally blame a father for doing.
I missed the part where he hit him with the shovel 15 to 20 times before stabbing him with the animal. I missed the part.
Yeah. So Minnesota man is behind bars and charged with intentional second-degree murder after police claim he beat a man with a shovel before finishing him off with a moose antler. Levi Axtell, 28, reportedly turned himself into police last Wednesday for killing 77-year-old Lawrence Scully of Grand Marais, Minnesota. On Friday, he was charged with murder, with bail set at $1 million. According to the court documents, police received a 911 call from someone who saw a minivan pull up to Scully's home before hearing screaming and seeing the van drive off. Axtell showed up to the Cook County Sheriff's Office moments later in a van fitting the description, covered in blood and demanding to be handcuffed. So this isn't even a part where he's essentially bad person, like not good. Don't take law into your hands. Do not do this. This guy drove straight to the police station and said, cuff me now.
Covered in blood, which I think the police would accommodate you.
Yeah.
Yeah.
Yep.
Now, I mean, a fun prank would be to do that, and it's not people blood, but
I'm not sure that you would have the same definition of the word prank.
That's not
that doesn't end well on you.
Or
the police would have fun about it later.
I don't think any of that's fun. That's terrible.
The police would be amused later.
Yeah.
Not at the time, but later.
They'd probably charge you with filing a false police report or something just for making them irritated.
I mean, that would be part of what they would find funny.
So Axtell told the authorities, so he admitted to the crime, admitted to hitting Scully with a shovel from the plant's porch 15 to 20 times before finishing him off with a large moose antler. The finishing him off part, that's in the damn statement. Deputies later found Scully at his home, obviously dead from the serious nature of the head wounds. As for why he did it, Axtell told the police he believed Scully to have sexually offended against children in the past and believed he would reoffend. The outlet also credited Cook County Sheriff Pat Eliason with confirming Scully was convicted. So the police came straight out and said, we're going to confirm this previous conviction. 1979 sexual assault of a 6-year-old girl before being released from prison in 82. Axtell previously requested a protective order from Scully in 2018, alleging that Scully was stalking his children in his van and writing, him attempting to groom my daughter is completely inappropriate, needs to stop. He was granted that order on a temporary basis before it was dismissed several weeks later.
Was it a white panel van?
This is one of those cases where like, I'm going to keep the jokes at a minimum because this is one of those where the moose antlers is the only funny thing that happened and not funny at all because wow. And I don't know that after I read this, that I don't know that I blame any man or any father in this person's position. I can't say that I don't blame them. There's no right answer here. Don't kill the person. Morally, I don't know that I could say that to a father. That's the conflicting part. Like legally, don't do the thing.
YouTube wise, also don't do the thing.
That one too. Thank you, Ian. Yeah. So this got dark real quick. He gets arraigned. He's arraigned and he's got the next court appearance April 10th. Like I said, this one was one of those where I couldn't not say something about a man that was killed with moose antlers. But the more that I read about the story, it's uncomfortable. They have a GoFundMe set up for the family, for the defense.
But not so much.
Sorry, did you say
they took it down? They took it down.
Yeah, they took it down because you can't.
Okay.
They don't let you do that anymore. It's against GoFundMe's terms of service. So that's not legal advice. That's just saying that some people will do some interesting things in Minnesota.
I mean, you pretty much have to. It's Minnesota.
It's Minnesota. So moose antlers.
Isn't that also where Fargo was set?
I think so.
It feels kind of similar.
Fargo, Wisconsin. Yeah.
Realistically, probably his best outcome is some sort of reduced plea.
It's a reduced.
Maybe the prosecutor will offer voluntary manslaughter or something if he's lucky.
He'll plea out. You think he'll get a reduced?
He might. Sometimes they take that as making it more more serious.
Fargo's North Dakota because we all cannot remember that it's Fargo, North Dakota. Wow, that's a fail on all three of our parts.
Fair.
This is a plea deal, like 10 out of 10, because the last thing you want is something from like Philadelphia, like where it's the the dad that's testifying, or not Philadelphia.
Yeah.
What was it? Samuel L. Jackson.
Oh, Time to Kill?
Time to Kill.
Like that was Deep South, wasn't it? That was like Alabama or something, wasn't it?
The last thing you want is the time to
Mississippi,
kill
something like
moment in
that?
court. Yeah, you do not want to be the prosecutor bringing this case. You just don't. Like you are pleading this out. So, Ian, do you still want to cover the moose murder, the moose antler murder on Monday? Because it's not really Monday Fun Day.
Yeah, I mean, I think we've covered the aspects of it. So,
you sure? I that got dark. In other news, Kurt, what have you been covering on your channel? Because I want to run away from the moose story.
Well, I'm not sure if you want to run towards this topic or not, but the last 2 videos I've been doing is about transgender youth in sports.
I'm fascinated.
I did a deep dive. I tried to do a fairly balanced legal analysis because what I tried to point out is that the underlying legal issues, if we're looking to be intellectually consistent from an originalist perspective, the answer might very well be the state can do what they want, and it might be able to be the answer might be that they can do what they want either way. So I did a sort of summary story about 2 cases, West Virginia and 1 in Minnesota, where they've taken completely opposite approaches on this issue. And then I did a deep dive today on the one on West Virginia. And I pointed out that it, even though one state has basically said no to the transgenders and the other said yes, mandating it, basically said, no, you can't do this. And the other said, yes, you must do this. I pointed out that from originalist perspective, both answers might be correct.
See, that's the part that's fascinating. Is from you take it from the legal perspective,
right?
And how both.
So if you ignore the underlying policy question and just look at it legally, like, is this a good idea? If you ignore the policy question of is it a good idea, and you just be like, is it legal? Then to some degree you avoid some of those problems.
Well, and the other part about that one, is it legal or is it not legal? Then what that does, it goes back to the legislature and it says, here's what you can do and cannot do to make the changes you need to enforce the policy that you want to enact. That's the part that's frustrated me, is the law is not, legislatures make the laws to enact policy that they believe is in the interest of the body politic.
Right.
That's the part.
And laws by their nature are line drawing, because you have to decide what the law is, right? You have to decide what's legal and illegal, and you have to decide where the boundaries are. So if you assume the premise that there should be men's sports teams and women's sports teams, which incidentally, the person suing in West Virginia said there should be. So they're transgender. Their argument isn't there shouldn't be men's teams and women's teams. That wasn't their argument. That could be an argument, but it wasn't. They said there should be men's teams and women's teams. I should just be allowed to be on the women's team. And so then you have to say, okay, so then you have this question, like a person shows up and says, I want to play soccer. There's a men's team and a women's team. How do you determine which team they play on? And there has to be some policy answer behind that, because you have to make a decision.
And
it can't be both.
The part. That's the part where it's these answers are not easy. They are difficult. But the thing is, there has to be a method of deciding in one direction or the other. And that's where it comes down to writing down the law.
Right.
So either way, what I wanted to do, we'll do a
we could also talk about the Fifth Circuit judge in Stanford, because someone in chat reminded me, if you want to move on to a less controversial topic.
That I would love to do. So let's do a swoopy swoop, and we'll go and move on to something that's less controversial and more fun, in that Stanford just loves to just be the bane of all legal existence. I don't swoop.
So Stanford Law School is where good law goes to die, apparently, in every possible way. And it's also where just good logic goes to die, not the person,
not the person.
Yeah, I was going to say, not Joe.
The concept.
Bad phrasing. Because Sam Bankman-Fried with Stanford, and so Stanford Law School, the Federalist Society, brought a Fifth Circuit judge to talk at Stanford Law School about the Fifth Circuit. The talk was supposed to be titled "The Fifth Circuit in Conversation with the Supreme Court: Guns, Twitter,
and
COVID.
something else.
And COVID, guns, and Twitter."
Yeah.
And these are three topics the Fifth Circuit has spoken about recently.
These are things.
The damn associate dean of the school tried to shut it down.
Well, that's the thing. It's not the topics. And this is the problem that pissed me off. This judge is talking about the circuit split and how the Fifth Circuit, among the 10 circuits, is communicating with the Supreme Court about the issues that they are seeing in how to interpret the law. And it's I think Kurt phrased it great, because I watched that video where you did the breakdown of it, and it was the circuits are in conversation with the Supreme Court at all times, as the district courts are in conversation with the circuit courts. It's a bilateral conversation. The district courts are communicating upwards to the circuit courts, and circuits are saying the district courts are saying upward to the circuit courts. This is the precedent that you have asked me to enforce. When I enforce it, this is how it plays out. This is the question that you have left unanswered. I have to look to the other circuits in how to answer that question. And the circuit looks down at the district and they say, you got this wrong, you got this right. Here's how I want you to do it. And then when they get an answer, a question that they have not had to answer before, they say, how do our brethren circuits answer this question? And they say, I think this part is good in that answer. This part's good in that answer. This one we don't want. So they embrace that in their own test. And then they have a conversation with the Supreme Court, where it's kind of like, Supreme Court, this is our interpretation based on these different things that are out there. We know that we disagree with this circuit, and this circuit. This is how we're reaching our conclusion. Please tell us how we're wrong. And if we are wrong, how do we fix it? And the Supreme Court's either like, nah, don't care, not going to listen, which they do 9 times out of 10. 1 time out of 10, they say, good point. Let's resolve this. It's a discussion.
1 time out of 140, more to the point, but yeah.
Ian, are you dying right now?
Yeah, I think the chat is probably smarter than I am here. I got a migraine kicking into full gear, so I'm going to bow out. I think I brought it on doing too much clunking around in the yeah. I had to do a lot of digging and so forth. So I will toast you guys with some hot sauce. And,
oh God, how is that better for you? Oh,
it makes something else hurt.
Fair.
That's unfortunate.
Okay.
Might take my mind off it, but yeah, I think I'm gonna go try to be unconscious so that, I mean, I'm still hoping to go shooting tomorrow, but if it's rocking like this, then I'll have to bow out. But
okay, yeah, get better, get some rest.
All right, night, folks.
See you, Ian.
Yeah.
So
I you know, this is a law school, and it's a sitting Court of Appeals judge, and this should be like the most obvious match known to man. It's like you can agree with him or disagree with him, but he's a person who's obviously in a position of authority, and he's giving an interesting conversation. It'll be interesting to see how he perceives his relationship with the Supreme Court, and whether or not he perceives his relationship with the district court the same way. Is that the same, or is that different? Like, is that if to the extent, for example, the Fifth Circuit feels frustrated by the Supreme Court or whatever, should district courts feel that way? It'll be interesting to see how they deal with the conflict and resolution, and how they go about thinking of things. And the associate dean of the law school, whose apparently official title is Associate Dean for Diversity, Equity, and Inclusion, which immediately just basically will be like, I'm going to let you finish.
Oh, don't say that.
I'm going to let you finish.
Taylor Swift, the Kanye Taylor Swift reference.
Yeah. I'm going to give a 6-minute monologue first about, is the juice worth the squeeze? Is it worth the division?
It was bad.
for you to be here and talk about these topics, I'm like, what the hell are you talking about? Is it worth the division? Like, do you understand like law, like at all? That
Well,
there's
and
the nature of law is in the nature of conflict.
it's the nature of disagreement. And here's the thing. Here's a question. So not a question. Here's I'm going to give an unsolicited opinion. And for those of you who don't like it, that's fine. I don't care. So I know that there's reporting out there about the Federalist Society and whether they are some ultra conservative sect of jurisprudence. I don't care if you believe that or not. I don't. The fact of the matter is that these individuals are part of the American and the judicial dialogue, which means that communicating with them effectively through reasoned legal argument is just as important, if not more important, than just ignoring them and pretending they don't exist, because there are jurists that are on the bench that have that viewpoint. The same thing goes with very, very permissive, and I mean from a legal interpretation standpoint, liberal justices. Little L, little C, little L, little conservative, little L, little liberal.
Mm-hmm.
There's different viewpoints on how to interpret law, statute, constitution, etc. All of these judges and all lawyers aren't worth shit if they can't talk or argue to both sides. You have to know how the other side thinks and operates. And if you're training an entire generation of lawyers who is taught simply to ignore one entire side, whether that's the conservative side, or little c, arguing against or ignoring the liberal side, or the liberal side arguing against or ignoring the conservative side, if you're not teaching them how to make the arguments, you're not doing your job. You're not being a law school. You're not teaching lawyers. So,
right. And also from a pragmatic standpoint, because understanding how someone thinks and their values tells you how to make an argument to a way that would appeal to them. Because because there's a lot of different ways you can go to attack a problem or attack an issue. And not everyone cares equally about all kinds of values or all kinds of ways of measuring things. So it would be extremely helpful as an advocate to understand the kinds of things your judge cares about. We've talked about this a little bit on you can look at this in a completely non-ideological level. For example, we talked a little bit about this when we were doing Johnny Depp coverage, because we were talking about Judge Ascarati. And we're talking about how, for example, she viewed issues like foundation and hearsay as an example, and like how she drew those lines and how those issues were important to her or not important to her. And you've seen also in other cases that we've covered how, different judges, how they care about different things, what they do or do not care about, like the Murdaugh trial recently, in terms of what that judge cared about or not. He doesn't care about certain things in a certain way. And on a very practical level, it's very helpful to understand how the judge is judging, because then you know what to give them, because this is what they want. If you're trying to get hired for a job, it would be really helpful to understand what they care about, because then you can bring out those qualities and make sure that you mention those so that they understand.
Well, and
so
here's
and you can get some interesting results sometimes when you do that, because if you're talking to an originalist, if you frame things in a particular way, like I was talking about this just 3 stories ago about whatever transgender issues, like if you frame it to me like a transgender issue, and you're like, this is an issue of state rights. States should be allowed to do what they want because they're free. I'm like, ooh, tell me more. Right? You're not making a moral argument, or you're making a different kind of moral argument. You're talking about where the power is.
Who makes a decision?
Right, which is what I care about. So if I'm a judge and you're coming to me, it would be helpful to understand that, so you make the right argument.
And this is the part. So there's been questions in the chat, and I'm trying for the most part during these discussions. I don't like having a lot of people influence how I'm perceiving the discussion, because I think it throws me off of any logic there. My thing is, a question was asked that was kind of important. It's where do you and how do you set the moral standards for society? And how do we determine values in the country, the value determination argument? And the funny thing about that is, as lawyers, honestly, 100% honestly, that's not up to us. We don't determine the values or the morality. We don't do that. That's not the job. And I know that people say, well, how do you disconnect or how do you do that? It's not the job. It's preservation of the system and making sure that that system allows itself to work, that it puts the power in the right hands where society gets to dictate what values and morals are then put into law, and the lawyers then get to make sure that that law is carried out appropriately. That's the question. It's who gets to make the decision. Where does that decision come down to? And who's the appropriate person to make the argument that the decision should be one way or the other? And a lot of these questions, there's a bunch of stuff that says political question doctrine, or you've heard these things brought up because the court is more, and I'm going to say this, more little c conservative in their viewpoint of who gets to make the decision. The people is where this court aims at pointing that question. And it doesn't mean that one way is right or wrong. There are different methods of judicial interpretation. Kurt and I could probably argue both sides of any one of these cases. That also kind of, we could. Whether we believe that one is stronger than the other is different and separate from that. Civil discussion and discourse and being able to have that argument is what's most fundamental and important. So lawyers are not, we are not the ones that make the moral calls. We don't do that. And people hate me for saying that. That's not my job. I don't go in and judge the morality of any individual person. I go and try to advocate for them to ensure that their rights are protected under the law, just as the rights of everyone else.
Yeah. It's an interesting idea because what you're also alluding to is the idea of legal correctness is separate from righteousness, which is also an interesting, because righteousness speaks a little bit more to morality. And so the idea the rain falls on the just and unjust alike.
Correct.
The unrighteous have legal rights. Who was it who said something like, I'm going to screw this up so bad, but said something like, if the devil themselves had the right case that they should prevail. I'm screwing it up completely, but that's the right idea.
I think I remember the phrase, and it was in a case. It was in an argument. I want to see if I can look it up.
Yeah, because it was a much more poetic quote than I'm giving it credit
It was
for.
and I used the phrase that you cannot write laws based on the worst of us, because the best of us will come to judgment under those laws. It's off topic. It's kind of nuanced and it's difficult. And what I always try to stress is that every single person needs to be taught, not by some higher education, but honestly, a lot of the education begins in the household, to listen and talk. And the listen part is so much more important than the talking part. Listen to the arguments and be able to digest what's being said and have the discussion. Have grace. That's probably the most appropriate way of saying it. Have the grace to have the discussion. So
Yeah. And I think, and also just, accusing just blanket accusations of people being immoral, or blanket accusations of people being, whatever, like racist, for example. It's completely impractical or unhelpful, because but it shuts down conversation also. And it might be true, but you're not gonna convince anyone of that. You need to convince someone that they're wrong, and it can be done. Daryl Davis, famous black guy who's got a nice collection of Klans hoods because he's taken them from the people who were Klans members because he convinced them that being racist was bad.
Yeah.
It can be done. So there
I mean,
is a
and
way to appeal to people in a way that you can reach people.
judges get things extremely wrong, and even at the highest court, at the very highest court. What was it? Buck versus Bell.
Oh my God. Oliver Wendell Holmes. That's a depressing decision.
Three generations of imbeciles
is enough.
Is enough.
Yes. Wow, Oliver Wendell Holmes.
Judges
Oliver Wendell Holmes, one of the greatest justices of all time. You know what would be great? How about eugenics? That's wow.
That is a precedent. That is Supreme Court. That was Supreme Court precedent.
Yeah. Still technically
And that's not even getting into the Plessy case. That's not getting into any of the others. That's humans are fallible. I mean, humans are remarkably fallible. They get shit wrong all the damn time. Judges get it wrong all the time.
Yeah.
So
I take some comfort in the concept that humanity as a whole seems to be becoming better off over time, and whatever moral blights we have, there seems to be fewer of them than in the past.
Yeah,
which is plus.
So the Stanford case, to put a bow on this one, the Stanford it was interesting because the dean gets out and makes this big statement about how the judge, is the juice worth the squeeze as far as talking.
It's such a stupid question to ask.
And the lecture does go forward. The judge ends the lecture like what? In 1/3 the time that he had set aside.
Yeah.
And then a statement is issued by Stanford apologizing for the conduct of the students and the dean that was there. Because this is a sitting jurist. And like him, hate him, whatever. Stanford graduates students ask for clerkships, judges talk. And judges respect each other. You guys might have opinions on how these judges are viewed by and large among general population, but even judges on the far right, far left, whatever position you want to say, they have people that respect them on the other side. Look at one of the most odd friendships that ever existed. It was cool. One of the coolest things of all time is the friendship between Antonin Scalia and Ruth Bader Ginsburg.
Right.
And how they would troll each other and how they would ruin each other's day by sending opinions to each other before they would go on holiday. Fucking love it. That's one of my favorite facts about them. How they would be like, hey, I'm going on this vacation, and RBG would send Scalia this dissenting opinion the day before he left, knowing it would haunt him that he couldn't respond until he came back. One of the coolest things in the world. Yeah. So Stanford comes out and issues that apology to the judge. And then the next day there's a damn near riot, not riot, like a protest on campus calling for the dean's head.
Which one?
There's no discussion. Dean? There's the one
dean
that
wrote the apology, or the dean who...
I think it was the dean that wrote the letter. It was the dean that wrote the apology. It's so stupid. There's no discussion anymore. I hate it.
I mean, law is to some degree applied philosophy. If you're not talking, I don't know what we're doing.
It's depressing. So
I once said that I liked law because it was the sort of culmination of the human experience, which is true. The law is basically the way that we have chosen to resolve philosophical conflicts over time, and how different values have competed against each other in a way that has formed the basis of our society. There's a lot of wisdom in that collectively, and saying let's not talk is just about the dumbest thing I could think of.
Well, it's
I
fun.
hate Stanford Law School, and I want them to drown into the sea.
I think that I am scared that they are educating future lawyers and how not to make discussion or how not to have
Are
a
they
discussion.
educating future lawyers?
I don't know. I don't know. I don't know what they're educating. I am scared about it, to be quite honest. It is wild. I am scared about the profession of law going forward. And I hope that I can be in this profession long enough that I will come across some young opposing counsel who is set in their ways, and I'll have the opportunity to try and change their ingrained perspective. The thing about the RGB and Scalia thing that always makes me laugh. Well, not laugh. Ruth Bader Ginsburg, everyone says, was one of the nicest humans in the world and had the heart of gold and all the other things that are attributed to her. And I do not discredit that. I think that she was awesome. I didn't agree with her legal reasoning. That's neither here nor there. I thought as a person, good person. For everyone that says that Ruth Bader Ginsburg was wonderful and a great human, and how could, and they look at all the other people on the bench, be mindful that Ruth Bader Ginsburg, that same person that you love so very much and trust so very much, she chose it upon herself with her heart, with her judgment, with her best judgment, and chose Antonin Scalia as one of her best and closest friends. That's her judgment. So when you go after like that, you're actually kind of throwing shade at RGB. If you say that Scalia was a monster and all the above, RGB said, "This is my friend." It's pretty cool when you think about it. And vice versa. Just think I don't care if you like Ruth or don't like Ruth. They chose each other. They were both friends. God. Sarah, I don't know. Well, it's a weird day. What are you talking about? I don't know. We got off topic. We did. Because it gets into the debate. I like these debates because the debates are fun. But I do have a docket, and we have one more item on the docket.
I'm excited.
Michael Irvin. So, Michael Irvin.
I'm still trying to look for this quote in the background. It's driving me crazy.
Shit.
I know we're close to finding it, by the way.
Shit, we have 2 more topics on the docket. Damn it, robot
Maybe
class
by
action.
the end of the stream, I'll find it and I'll be really happy.
Robot lawyers is first. Shit.
Okay. Ah, yes, the robot lawyers, the unauthorized practice of law, which, duh. I loved it when these people were saying, we'll pay you $1 million to sneak an earpiece into the U.S. Supreme Court and just let our AI respond to the oral argument they hear from the bench and just repeat it verbatim. That had to be this. Wow, that was a great moment. And everyone's like, no.
Yeah. The Michael Irvin one is going to be faster. So we'll do the robot lawyer because this one's curious. It's not the longest lawsuit. So let me do this. Kurt, are you familiar with the lawsuit itself or the premise behind the lawsuit? Oh, shit. Now I got to swoop. Let me swoop. Robot lawyer.
Oh, yes. Sure. Yeah. Companies like, wow, that was, let me try that again. A company said, we will create an AI bot. We will create a chat GPT, basically, that will help you fight your legal case. And do not pay, as it was indicated, was originally designed for tickets, parking, speeding tickets, that kind of thing. But they have expanded into other topics.
Mm-hmm.
And so come into our bot and we will teach you, we will tell you the things to do. And we're suing for unauthorized practice of law because that sounds suspiciously like the unauthorized practice of law.
Practicing law. So the nature of the action. Defendant, do not pay, claims to be the world's first robot lawyer that can help people with a range of legal issues, from drafting powers of attorney to creating divorce settlement agreements or filing suit in a small claims court. First of all, I am very cautious on anyone saying that AI can do a divorce settlement agreement. And that's just me talking. You know what? If the AI can do it better and provably do it better than me, fine. I just don't think that they can. Unfortunately for its customers, Do Not Pay is not actually a robot, a lawyer, nor a law firm. Do Not Pay does not have a law degree, is not barred in any jurisdiction, is not supervised by any lawyer. Do Not Pay is merely a website with a repository of, unfortunately, substandard, shade, legal documents that at best fills in a legal ad lib based on information input by customers. This is precisely why the practice of law is regulated in every state in the nation. Individuals seeking legal services most often do not fully understand the law or the implications of the legal documents or the processes that they are looking to Do Not Pay to help with. In California, practicing law without a license is prohibited by the State Bar Act. I don't know.
It's okay. It's okay
California.
because the California State Bar is here to save us by making sure that lawyers who are licensed are honorable and just and will take care of us, and they're really good in their supervisory authority. No problems there.
Do you know who wrote this? You know who wrote the complaint, by the way?
Is it the president of the bar?
No, Jay Edelson. He was the one that outed Tom Girardi.
Okay.
In the Illinois case. He was the one that went to the California bar, and the California bar was like, you have attorneys that practice in California. So I think this is some pretty good shade on behalf of Edelson. Okay. Which prohibits persons.
It's a good thing that we make sure that lawyers are licensed.
Which prohibits persons from holding themselves out as lawyers in California or practicing law in the state of California while not being admitted to the California bar. Despite this prohibition, Do Not Pay's robot lawyer provided and continues to provide unauthorized legal service to thousands of customers throughout the country. Accordingly, this complaint seeks an order: 1, declaring that defendant's conduct is unlawful; 2, requiring the defendant to cease the unlawful activities discussed herein; and 3, awarding damages to plaintiff and the proposed class. What's the grounds? How is the plaintiff injured? That's my curiosity here.
That's a good
Jonathan
question.
Feridian, go ahead.
I'm like, no, that's a really good question. Shouldn't this be coming from the attorney general or something like that?
How is the plaintiff injured? Like where is the standing? Did
they use the service?
I don't know, but this is one where I'm actually going to read some of the underlying crap here that I usually skip through. Plaintiff Jonathan Feridian is a natural person, a resident of Yolo County, California. By the way, Yolo County, you only live once. I love the county name. Defendant Do Not Pay Inc. is a corporation organized under the laws of the state of Delaware with a principal place of business in San Francisco, California. So jurisdiction is California Constitution because it's a cause not given by statute or other trial courts. Personal jurisdiction because it conducts business. That's fine. Venue proper because the conducted issue occurred in. Okay, fine. Factual background. The California legislature passed the State Bar Act of 1927 in order to regulate the practice of law. The State Bar Act sets baseline standards for attorneys in the state in order to protect California residents from being harmed or unskilled or unscrupulous laymen from passing themselves off as bona fide practitioners. They didn't do their job. Among the requirements set forth by the legislature is being licensed or authorized to practice law in the state of California. Absent such licensure or authorization, engaging in the practice of law or holding oneself out as a licensed practitioner in the state of California is unlawful. Do Not Pay holds itself out as the, quote, world's first robot lawyer, but is not actually a lawyer or law firm. Do Not Pay operates as an AI-powered chatbot that uses natural language processing and machine learning algorithms to provide legal advice and assistance to users through its website, donotpay.com. Do Not Pay was founded in 2015 by Joshua Browder, a British-American entrepreneur and software developer, initially as a tool to help people fight parking tickets, as Kurt said earlier. But Do Not Pay has since expanded its services to cover a range of legal issues such as filing small claims lawsuits, disputing property taxes, and even helping people access government services like unemployment benefits. I'm starting to see a problem there. Do Not Pay does not minimize its claims. It heavily advertises itself as the world's first robot lawyer. Ooh, advertising I still have standing questions, but the advertising stuff doesn't really do well.
Sue anyone with the press of a button.
Oh, shit.
Wow.
Wow.
There's a button I
Really?
can press? Where's the button?
Fight corporations, beat bureaucracy, and sue anyone at the press of a button. By the way, the bar in every state, historically speaking, hates anything with that implication of that last phrase. The bar does not like to, well, rather, the bar is pretty restrictive on any advertising that promotes initiating litigation, which is why a lot of the cases are, have you been injured? You might have rights. It's never sue this company because they're bad. Just saying. Throughout its website and marketing materials, Do Not Pay offers customers the ability to purportedly hire a lawyer at the click of a button to handle a variety of legal matters. Defamation demand letters solve this problem for me. Oh, okay. Wow. I didn't realize this was this in your
Greater
face.
power of attorney. Good.
Well, there you go, Kurt. What's that? Sue anyone in small claims court. I didn't realize it was that aggressive. Do Not Pay's marketing.
So anyone
worked.
small claims court is particularly interesting because in many states, lawyers, you're not allowed to have a lawyer in small claims. So the fact that this is potentially the unauthorized practice of law in small claims courts,
I didn't even think about that.
Stupid.
I didn't think about that because if they're saying they are a lawyer,
yeah,
have they?
And they're practicing specifically in small claims. That's a double problem. Yeah.
Huh.
Yeah.
And yeah, like what Kurt said, most small claims courts allocate the cases by jurisdiction, and a jurisdiction usually has a threshold of amount. And in small claims below a certain threshold, in Virginia, it used to be 2,600. If you're below 2,600 small claims courts, lawyers are not permitted to practice down there. You can have it removed to general district court.
Correct.
But
so you don't have to be in small claims if you want a lawyer. That's how you get around the issue of you're entitled to a lawyer. Because if you want a lawyer, you just take it out of small claims and take it to a different court. So, which you can do as a matter of right. But if you want to stay in small claims, you're not allowed to have a lawyer. So, yeah.
Interesting. Is lawyer a regulated term? Doctor isn't. It's not lawyer, Island. And that's a good question, though. It's not lawyer. I like this question. It's not lawyer. It's the practice of law. If you are engaged in the practice of law, and every state and most states actually kind of embrace the same thing that defines what that practice of law entails. And it makes it unlawful for people to do that, that extra step. People can say, for example, Chile de Castro, I'm a law scholar, constitutional law scholar. That's fine. You can say that. You're a scholar. Anyone's a scholar. You can say you're a legal analyst. Fine. Cool. I don't know if you can say you're a lawyer, but even then, I don't really see a problem with that if you're not actually advertising for clients or engaging in the practice of law. I can see it being deceptive if you're trying to make money based off of it, but the practice of law is what's at issue here. Do Not Pay's marketing has worked. In one example, Browder boasted on Twitter that Do Not Pay was hired to initiate over 1,000 small claims lawsuits, poor choice of words, related to a single cryptocurrency exchange. Oh, shit. Here's the quote. Here's the tweet. We now have initiated over 1,000 small claims lawsuits against Celsius Network in 42 states. Rather brazen with it, isn't he? But Do Not Pay is not a lawyer or a law firm, nor is its founder. Not surprisingly, Do Not Pay has been publicly called out for practicing law without a license, most recently in relation to a stunt in which it sought to actively represent a client in court using AI. In response, Do Not Pay's CEO deflects, blaming greedy lawyers for getting in his way. News Nation. Jay Browder was looking forward to his robot lawyer getting to argue its first case, but threats from real lawyers have halted his plan. He tells Leland Vittert that he underestimated the persistence of the greedy lawyers. we're going to get to the point where I think that some lawyers might have legitimate claims for this one. Look, if you want to come in and draft all my damn agreements for me, please do. Like literally, please do. But we might have a difference of opinion on the practice of law and whether, for legitimate purposes, AI should take that over. Sadly, do not pay misses the point. Providing legal service to the public without being a lawyer or even supervised by a lawyer is reckless and dangerous. That's the point I was kind of getting to. And it has real world consequences for the customers. It hurts, I would say, clients. One customer who I like the distinction. Good shade, Jay Edelson. Good shade. Customers, not clients, because they're not practice of law. One customer who posted an online review used Do Not Pay's legal service to dispute 2 parking tickets. According to his account, his fines actually increased because Do Not Pay failed to respond to the ticket summons. The customer then canceled his account, but Do Not Pay continued to charge a subscription fee.
Nice.
Oh, so now I'm starting to see where standing might exist. Do Not Pay's service then reversed another customer's argument in her parking ticket dispute. When she had intended to argue she was not at fault, Do Not Pay's services instead admitted fault and the customer had to pay a resulting $114 fine. To be fair, Do Not Pay might have been right, but the client kind of lost the say there. After backpedaling on his plan to have Do Not Pay appear in court via an earpiece in his client's ear, Browder issued a kind of mea culpa coupled with a product teaser on Twitter on January 25th, 2023. In this thread, Browder described a non-consumer legal rights products like defamation demand letter and divorce agreements as a distraction and stated they would be removed from Do Not Pay effective immediately. Well, this is funny because this is an area that I think I have some expertise in. At the time of writing, Do Not Pay's website still refers to itself as the world's first robot lawyer and continues to offer these legal products to the public. Casting doubt.
The plus side, Do Not Pay can consult itself for responding to this, so it's got itself covered.
Oh, please tell me they will do that. Oh my God. You should force them to do
How
it.
good are you, Do Not Pay? Let's find out.
Force them to do it. Yeah.
Real test.
You know what? If I'm Jay Edelson, I would put it like, come on. Why is that? Is there a remark in this lawsuit that suggests that they should? Please tell me there is. Please be one that in there that is. Casting doubt on its intention to stop masquerading as a licensed practitioner. Facts specific to the plaintiff, Feridian. This is what I'm interested in. Where's the standing? Feridian was a client of Do Not Pay until January 2023. Feridian used Do Not Pay to perform a variety of legal services. For example, Feridian used Do Not Pay to draft demand letters, an independent contractor agreement, a small claims court filing, 2 LLC operating agreements, and equal opportunity employment commission job discrimination complaint. Honestly, I can see why people would look to AI to do these things. And this is kind of the next step in the Rocket Lawyer or what's the other one, Kurt? There's Rocket Lawyer and they help you draft documents.
LegalZoom,
that one.
LegalZoom, incidentally, has gotten in trouble with state bar associations in the past for arguably similar conduct. So yeah.
Yep. Plaintiff Feridian believed he was purchasing legal documents and services that would be fit for use from a lawyer that was competent to provide them. Unfortunately, Feridian did not receive that. The services Do Not Pay provided Feridian were not provided by a law firm, lawyer, or a person supervised by a lawyer or law firm. The services Do Not Pay provided Feridian were substandard and poorly done. For example, the demand letters Do Not Pay drafted for him, which were to be delivered to the opposing party, never even made it to its intended recipient. Rather, the letters were ultimately returned undelivered to Feridian's home. Upon opening one of the letters, Feridian found it to be an otherwise blank piece of paper with his name printed on it. As a result of this delay, his claims may be time barred. Okay. Other documents Feridian purchased from Do Not Pay were so poorly or inaccurately drafted that he could not even use them. For example, Feridian requested an agency agreement for an online marketing business he wished to start. Upon reviewing the agency agreement drafted by Do Not Pay, he noted that the language did not seem to apply to his business. Even the names of the relevant parties were printed inaccurately. Feridian was ultimately unable to use this document in his business project. In the end, Feridian would not have paid to use do not pay services had he known that do not pay was not actually a lawyer. Okay. Brings the class action. So excludes judges, excludes other people, blah, 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 class. We're not going to do class qualifications, kind of boring. Get me to the meat of the lawsuit. The unfair competition law defines unfair competition as any lawful, unfair, or fraudulent business act or practice, an unfair, deceptive, untrue, misleading advertising, and any act prohibited by Chapter 1 of Part 3 of Division 7. My God, of the California Business Professional Code. Chapter 1, Part 3, Division 7. Why can't there's got to be an easy way to type that. In the course of conducting business in California, the defendant committed unlawful, unfair, and or fraudulent business practices by holding itself out to be an attorney, okay, engaging in the unlawful practice of law by selling legal services to residents of California, okay, violate obligations imposed by statute, and substantially injurious, they cause harm, offend public policy, and are immoral, unethical, oppressive, and unscrupulous as to the gravity of the conduct outweighs any alleged benefits attributable to such conduct. This is fascinating now. So there's the asking price thing in here, misleading, business practices, etc. So a lot of this is pretty safely argued. They don't really go after the meat of the argument here in whether AI can or should be allowed to engage in any form of practice. This is kind of like it's the safest argument he can find. What do you think, Kurt?
Yeah. The technology's not there for it. I think the use of AI in legal practice, AI has some value, particularly in sort of discovery, because it can help you in sort of going through a lot of documents and finding things. And it can be helpful to attorneys in drafting things and particular sections, but it's not ready for the consumer level at this point. So
well, yeah, and
anyone
let me
who's
give you
advertising it, it's not ready for that.
And let me give you the example. So one of the ones that
Notwithstanding
was there,
ChatGPT can pass the bar exam, it's still not ready for it.
Well, that's fair. I think that there's AI at this current stage is a very useful tool. And I can imagine asking AI, for example, proofread my appellate brief.
Mm-hmm.
Okay. And then I go back and I look at what they have proofread and gave back to me. And then it passes an obligation back to me to double check everything that they have said. Make sure the case law is still good. Make sure the argument is still in line. And then most importantly, check with my client. And the thing with like a divorce complaint or a marital settlement agreement, let's say that goes haywire. You're left to sue a company that could be defunct and would have no ability to provide you with any recourse. Most states, for example, in Virginia, I have to maintain malpractice insurance. If I screw up and I commit malpractice, my insurance company pays out for that malpractice. For those attorneys who don't have adequate coverage, there is a fund that is set up by the state bar for claims to be paid out in some proportionate amount or some amount by the bar because we're self-regulating and we recognize that part exists.
Mm-hmm.
Who do you go after?
I still have to pay $25 a year as a Virginia lawyer towards
to the Virginia State Bar.
Yeah. Towards the client. The lawyer stole the money for the client fund.
Yeah. So who do you go after? Not just when you don't get the product you asked for, but when the product you asked for ends up putting you in more legal trouble than you thought you would be in. I don't know. I think that AI is a great tool. And I think that's going to be the way the future goes on this. It's going to be a tool. But as far as automating the practice of law, I understand that the legal practice needs to be more available and approachable. I get that. This part, though, scares the hell out of me because there's too much of it where people end up in a lot more trouble than they would be if they had gone to court by themselves alone. I don't know. It's tough.
I think I think that technology is coming along pretty fast, and I think in 10 years' time,
It could be.
I think I'm taking a look at sort of the development in AI, which is a little tangential, but you've got realistic deep fake audio, realistic deep fake video. It's getting to the point where it's harder and harder to tell. You got ChatGPT, which is putting together stuff that can compete with high school or low level college level writing in some senses. You've got now integrated with Bing searching the internet and putting together stuff, and it is already fairly impressive in what it's doing. These technologies, and they're developing rapidly. Like Midjourney has just came out with version 5, and version 4 didn't come out that long ago. ChatGPT just came out with version 4.
Mm-hmm.
And have been using 3.5 not that long ago. So these technologies are really up and coming. Ray Kurzweil, who won the MacArthur Genius Grant, MIT guy, wrote a book called The Singularity. And wrote it, I don't even know, 30 years ago at this point, and basically predicted that he thought that the first general intelligence AI would be invented circa 2035. And I'm like, yeah, that sounds about right, given the pace of technology and technology growth.
That makes sense now with what we've seen.
Yeah.
And the thing is, I think you're right. The other thing is the rapid development of things like ChatGPT and other AI platforms is the rapid growth leads to a little bit of a delay in finding the errors, but the errors are eventually found. There are some flaws in ChatGPT. I saw something in the chat saying that they just received a notification at work they're no longer to use it. And I know other people have run into similar errors as well. I liked Syracuse Brad's comment. ChatGPT writes in motion a case, lawyer reviews for accuracy and confirmation of the arguments. I pay lawyer for far fewer hours of work they'd otherwise spend writing. And to be honest, here's the thing, Syracuse Brad, the lawyer is able to handle more cases because they are using less hours to do the writing. So the efficiency isn't just onto the client, it's onto the lawyer as well. So I think that you're right. I like this model. I think this is the next natural approach. I just don't think we're there at the fully automated part yet.
Oh, no, we're not. We're not. It is not ready it is not ready to go outside of a professional using it as a tool.
Yeah.
That is the limit of its value right now. But I think the day is coming relatively rapidly when that will be less and less true.
Yeah. I would like to, I think that's the next part. I think there's going to be classes teaching. Honestly, I wonder if there aren't a couple lawyers trying to figure out a CLE on like tips of using ChatGPT as a research tool. We can't be that far off from it. Using ChatGPT as a vetting your legal arguments through ChatGPT. You put your legal argument and you ask ChatGPT, give me a response in the tone of Antonin Scalia, right? And it responds to you and breaks your argument down. And now you can go and preview your argument and then go back and refine it. I think it's a great tool. So let me see if there are any questions here because I want to get AI is great. Thank you, Real Sarah. Thomson Reuters document intelligence uses pre-trained AI to read, organize, and manage legal documents and process critical business. That's cool.
I mentioned that at the very start where I mentioned that AI is good. This is basically discovery. Read, organize, and manage legal documents. It's basically discovery. So it can be very helpful with that technology.
I would love that tool, to be quite honest. I would love that. RBG trying to change them like gals do as to Scalia. You never know. They poked fun at each other. It was fun to watch. I love that relationship. Virginia Tracy, moral judgments are very difficult in a body politic as diverse as ours is. Morality is usually the realm of religion rather than law, but our country has a huge variety of religions and none. That's not far off.
I don't know if morality is necessarily only religious, because if you're asking a question, I don't. Yeah,
morality
predated. I don't know if you can. Huh?
Morality predated religion.
Well, yeah, that's probably true. Yeah, I mean, yeah, because you see what could be deemed morality in other species, and sort of
Mhm.
reciprocity, acts of service. So that's fair. Morality may predate the human species. So yeah, but to say like how you should, I mean, even a question like, should I save my own child or should I save a stranger's child first? I mean, that involves a moral question. I mean, we all think we know the answer, but I don't know how you could assess such a question without asking a moral question. Because I mean, from a completely objective standpoint, those two lives are equally valuable. I mean, we would all agree on that. But if you're the father of one of them, most people would agree that they're not equally valuable to you, nor should they be. Isn't that inherently a moral judgment? Okay.
I mean, it's a discussion. The point of the dialogue, the point of bringing that up is that discussions need to continue. They need to happen. So, Rua, thank you very much. Rob in lawyer shade mode is fun. I have fun with some of that stuff. Jules, thank you. How must be slow legal week if you found North Minnesota story of antler killing. No one seems to find fun legal cases here in Minnesota. It was interesting. Tiffany Bernier joining. Thank you. Steve A, when you're falling off a cliff and a loose clump of grass, the only thing that might save you, you grab for it. That's what SBF is doing here. I don't hate the argument. I just think it's not really well founded. M169, thank you. An Irish blessing. As you slide down the banister of life, may the splinters all be pointed away from you. That's a fucking good one. That's a good one. I like that. Happy St. Patrick's Day. Thank you, M169. Torin, I do the braiding on my channel. Oh, Torin, thank you for saying that. Torin does these really cool braids. Check her channel out. She can post it in the chat. If she does, someone else highlight it for me, please. Torin, Ian, your Kumiko. Oh, this was in reference to that. Ian, your Kumihimo braid is now 1 foot long, 4 feet left to go. Rob, I can start on your design for the braid whenever works for you. Those braids are really cool. Thank you, Torin, for sharing that. I love seeing the work you guys do. Rua, thank you. SPF is doing an AH. Kind of looked like it. Really kind of did. Melissa, I know you said happy birthday to people already, but I was late on here. It's my birthday today. I just wanted to say that we are the same age now. Melissa, happy birthday. I hope you have a wonderful, wonderful, and happy birthday. As I hope everyone who had a birthday today and this week has a great birthday. So happy birthday to all those born on St. Patty's Day or the week that embraces it. Tiffany, it took me a minute. I got there. Joining means refer to the range and gym. It took me a second. I did remember. It just, the delay in the mental cognition, it fired, as did the gun that I will be shooting at that range whenever I go. All right. Last case on the docket today, and then we'll get out of here. Shouldn't be too long to cover. Let me do a real quick swoop. Michael Irvin. Oh, Michael Irvin. For those of you who don't know, Michael Irvin is is he Hall of Fame? He is Hall of Fame. Yeah. Hall of Fame receiver for the Dallas Cowboys. And Michael Irvin was slated to announce or be part of the panel announcing for the Super Bowl this year. That is, until a certain person made an allegation of inappropriate conduct at a Marriott. And let me see if I can pull up the article because that will give us context. And then we can watch the video. Find the right one. Let's do this. We'll do the Channel 4 article. So there we go. All right. Move this over so I can see it. Michael Irvin refiles a Marriott defamation lawsuit in Arizona. So he originally filed in Texas, then voluntarily dismissed it and brought it in Arizona. I think that was a jurisdictional thing. And we go from there. Lawyers representing Michael Irvin said on Monday they withdrew his Collin County $100 million defamation lawsuit against Marriott Hotels and immediately refiled the case in Arizona, adding new defendants, including the accuser. The former Dallas Cowboys wide receiver also said Tuesday he was monitoring. You go away, you box of video. We'll go there in a minute. Said he was monitoring for CTE symptoms after being accused of assault. Irvin's legal team filed the original defamation lawsuit against Marriott International after he was sidelined from the Super Bowl duties as a sports commentator in the wake of an allegation of misconduct from a hotel employee in Phoenix. Irvin's attorney said Tuesday they voluntarily dismissed the Collin lawsuit without prejudice on Monday and immediately refiled the case in Arizona. Irvin's attorney, Levi Catherine, said Tuesday the original lawsuit didn't name all the parties involved, and that now that more information has been learned, it made more sense to file the lawsuit in Arizona. Said the lawsuit again includes Marriott Hotels, but adds the company that runs the hotel in Phoenix, Renaissance Hotel Operating. So yeah, there's hotels oftentimes have operating companies and ownership companies. So he wants to sue them both. Makes sense. Along with three named individuals and the complainant identified as Jane Doe. They also played a video Tuesday obtained from the hotel that he said showed the video victim interacting with an employee for less than 2 minutes in the open area outside the bar. Of the interaction, the attorney said the woman appeared to be happy as a lark and questioned why another employee nearby appeared frustrated by her interaction with the former NFL player.
I don't really understand what is going on in this argument at all.
So here's the thing. Marriott comes out. Here we go. This is what it is. The basis of the argument is that Marriott made a remark after Irvin had this interaction with this young lady. Marriott's remark publicly caused Irvin to be removed from coverage of the Super Bowl, which is a substantial amount of money that he would have made. Irvin said that's bullshit. Gets the video of the encounter. The judge in the Dallas case, before they chose to dismiss the case, the judge said, Marriott, give Irvin the video. Don't change it or modify it.
Mm-hmm.
Irvin, you can release it.
Okay. I mean, if this video was supposed to depict the moment of the alleged
unwelcome sexual advance,
then that would be extremely dispositive. If this is supposed to be what it is, then that would be very helpful.
And that's where this is. So the security video is kind of where this comes down to. So we're going to watch that and then we'll go to the lawsuit. You know what? Let me see if I can find the actual allegation.
Shown the video in the presence of the other attorneys, but not allowed to. That sounds like some BS discovery. I don't. Yeah, it's like we'll let you view it in our office. No, you're going to give it to me, and I'm going to review it in my office. Thanks.
Yeah. So it was Jane Doe that filed the report accusing Mr. Irvin of inappropriate conduct towards her. Based on Doe's allegations, Marriott, who presumably had access to the video, reported the information to the NFL. And Irvin was expelled from the hotel, so kicked out of the hotel without, this is the allegation complaint, without warning, explanation, or opportunity to defend himself. And based on the report to the NFL, he was removed from his broadcasting appearance. So Marriott, who presumably had access to the video, sided with Jane Doe and said, Mr. Irvin, get the hell out of our hotel. Sent the report to the NFL and said, NFL, look at what your guy's doing. Let's, yeah.
Yeah, the internal conduct within Marriott's probably legal, but where they're making a report to the NFL, that's more problematic.
That's the problem. The conduct internally is different. Let me see if I can't find it.
Yeah.
Why am I having trouble with
because
the video? Give me 1 second.
Because her report to her employer is probably legally privileged. So it probably doesn't count as defamation. You'd have to get in the state specific law, but there's definitely an argument to be had because you're relating it to for like an official purpose. It would be like going to the police in a similar context. So the report to her employer is probably privileged, and them simply saying we're kicking you out is probably fine, but it's not certainly defamation, because they can refuse to do business with anyone as long as it's not on a protected class. So that probably is okay. The problem is probably where they're reporting to the NFL, and the NFL is taking actions based on those representations. So,
Yeah, so let me see if I can. I'm going to pull this up
yeah.
and I'll share it. Give me 1 second here. And I want to make sure I can hear it because I wasn't hearing it before.
Stephanie, in
Why
answer to your
wasn't it playing?
question in
Come
chat about tortious interference with contract, the tortious interference in this context would be his contract with the NFL. He has a contract with the NFL to provide commentary for the game. So his contract is between him and the NFL. Marriott now, as a third party, is coming in and trying to break up that contract or interfere with that contract. So that would be in the nature of tortious interference. Basically, this is not your business. Why are you involving yourself?
Yeah, get out of the business. And it's overstepping is the art. It's like basically overstepping.
Yeah.
Or rather interfering in a way. Let me see. Let me do this. Just tab instead. There we go. There's a business expectancy that Irvin has. He has the expectancy to essentially earn this money from the NFL broadcast, that you essentially didn't need to interfere yourself in that. And by doing that, you effed with his pre-existing deal and you didn't have the right to do that. So here's the video. And I don't think there's audio to it, not the video itself, because it's just the surveillance. But they do highlight it. So
I'm
this is
not
the video.
sure. Yeah, if all they have is video without audio, I'm not sure that necessarily proves or disproves anything. I mean, I guess it's some evidence, but I'm not sure how much value it has.
Apparently there are 2 other witnesses Irvin says that he has.
That would be a lot more helpful.
So there's the female employee. Mr. Irvin, who walks over.
Also, there is an underlying normative question that we are not asking here. Which I don't know if you want. Okay, so they're interacting, but I mean,
well, let me back up real quick. So that's the thing, like the initiation of the interaction, right? So he's walking over here and she's there. He gets her attention. Okay. Interacting, don't see anything. They're in public space. So the notion that there are witnesses that hear this is not surprising at all. Communication, don't know what's being said.
It's right in the middle of a public lobby, so there's no attempt to keep the conversation private at all.
Communicating with, I mean, yeah, she stepped back. I see people saying she stepped back. I guess she stepped back.
I don't know. It doesn't look like to me like she's really stepping back. It just looks like normal movement of people that are talking to each other. Most people move a little bit in their positions. And also people are just trying to gauge their own personal space. It just looks like people, it doesn't look like she's moving back. That's not how I describe it to me.
There we go. That could be. I mean, I don't know.
That's not a sexual assault. I don't
know. Whatever that is. I mean, if that is the touching, if that's the touching that they're alleging, and they shake.
I mean, I can't really see anything from this interaction that strikes me as.
I don't think it helps one way or the other. I mean,
I don't
here's
think-
the
yeah,
thing. I don't think it hurts him. That's the thing. I don't think it hurts him. I don't think it helps him or her or helps Marriott.
Yeah. Yeah, I doesn't really strike me as anything. I mean, they're friendly, but of course, staff members are
Now,
trained to be friendly. But
here's what I will say. If Irvin's two witnesses, and this is something that it's going to be kind of interesting. If his two witnesses are these two gentlemen who are kind of like walking with him the whole time, then you're kind of looking at it a little more skeptically.
yeah,
But
there is an underlying normative question here about what sort of behavior is acceptable in sort of principle, especially when it comes to men approaching women with potential romantic interest.
or not romantic interest. That's the other thing. Not
Well,
even
it's like,
romantic
yeah,
interest.
if you assume that he was approaching her with some sort of romantic interest in mind, is that okay? And if not, then under what there's an underlying normative question here about under what it's like. So the issue is if someone's working, you're not allowed to ever approach them with romantic interest. So is that the rule? I mean, I have questions.
I don't know. I think here's where I'm going to come down on this one. And I think it's kind of the appropriate place to be at this stage of the proceedings. We don't know one way or the other. No one does.
Yeah, not based on that video. That's sure. Depending
Not
on what
based
was
on that
said,
video.
Depending on what was said, it could have been really raunchy and really.
I mean, it's I look,
Problematic.
I see in the chat you guys are divided in how you're viewing this. There's this she steps away defensively. I see that's normal interaction. I see that too. I don't think there's anything near enough in just this video to say that what Marriott said was true or demonstrably false. I am curious why Marriott didn't want to turn it over. I'm curious about that. But y'all can form whatever opinions you want. It's just a video. It doesn't really give you very much. Physical actions can constitute assault. Like I said, it can be sexual assault or just non-sexual assault, an unwanted touching or the anticipation of an immediate touching that is unwanted. Words in combination with physical actions can lend to the apprehension that someone is about to commit an unwanted touching. So the words would matter in some fashion or not. I'll tell you right now that based on my view of that, let's look at the allegations. Let's look at exactly what Marriott said. How about that? Before we go and try to analyze, let's look at what Marriott said. What forms the basis of the defamation? I think that's probably the safest way of going about it. So, the nature of the case. At the center of this case, is an incident defendants allege occurred at the Renaissance Phoenix Hotel downtown when Mr. Irvin was a guest at the hotel while in Phoenix to cover the Super Bowl. Following a brief, friendly interaction she initiated, arguable, based on the video, a hotel staff member, Ms. Doe, falsely accused Mr. Irvin of inappropriate conduct towards her. Based on Ms. Doe's false accusations, Marriott Renaissance reported the false information to the National Football League, and Irvin was expelled from the hotel without warning, explanation, or opportunity to defend himself. That report led the NFL to remove Mr. Irvin from his long-scheduled Super Bowl-related programming on multiple networks, interfered with numerous planned appearances at various Super Bowl events and fundraisers, and caused Mr. Irvin indefinite suspension from further appearances at and coverage of critical NFL offseason events. Defendant's misconduct, as detailed herein, has also severely impugned Mr. Irvin's reputation and predictably interfered with Mr. Irvin's future business relationships. Here's the thing. Regardless of what you think, if what was said by Marriott or Ms. Doe, and I'm saying if it was false, all of these consequences are a natural consequence of that allegation. it is easily understood that an allegation like that with regard to someone who was slated to broadcast or be a part of that crew, when made to the NFL, the employer, would result in these things. Now, it all turns on whether the statement is true or not. Mr. Irvin appreciates the opportunity to spend time with his fans, including taking photos and speaking with them. Mr. Irvin acts graciously and courteously during interactions with fans. Mr. Irvin's brief interaction with Ms. Doe was no different. Multiple eyewitnesses verified that Mr. Irvin casually exchanged pleasantries with Ms. Doe for an approximately 1 minute, shook her hand, and then went to his hotel room. In rushing to act before determining the truth, defendants acted in willful disregard of the severe impact of their false accusations upon Mr. Irvin, his family, and his livelihood. The damage caused to Mr. Irvin by defendants' actions has been swift and catastrophic, devastating Mr. Irvin personally and professionally. He was pulled by the NFL from covering the Super Bowl, the apex of assignments in his field of work, with scores of media outlets reporting that it was due to misconduct by Mr. Irvin towards a female hotel employee. Even after Mr. Irvin offered multiple independent eyewitnesses who would confirm propriety of his behavior, defendants refused to address and remedy the situation, just as Marriott and Renaissance refused to investigate the matter before falsely reporting it. That's the crux of the argument. That's what he's arguing, is like, you just reported it. They have decided that the risk to them of ruining Mr. Irvin's relationship with the NFL, its television network, and other NFL-related organizations is worth taking rather than admitting and trying to ameliorate their own reckless actions. I can see the other side of this coin too, because Marriott's probably nervous they're going to get sued by Ms. Doe if they don't do something. So, but again, open an investigation. Right? Kurt, are you following me on this at all?
Marriott's in a bit of a no-win position, which is hilarious.
They're kind of
the consequences of the culture we've built.
They're damned if they do, damned if they don't. They either believe the employee and make the report, or they believe the professional and risk the lawsuit from the employee. But couldn't they have just said, we're going to open an immediate investigation, we'll give 48 hours to see everything? It doesn't even look like they looked at the video. I'm curious. And L, let me clarify this. It wasn't the culture we've built. The culture we've built, we're essentially accused first, regardless of who's making the accusation, male or female, and then ask questions later. That's what he's referring to. That's what I'm referring to. Accuse first, ask questions later. Yeah. Marriott is registered Arizona, blah, 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 registration, office, yada, yada, registration, blah, blah, blah. Employee, people with capacity to act, jurisdiction and venue, Maricopa, not going to challenge that. Allegations common to all actions. In early February 2023, Mr. Irvin's traveled to Phoenix to work as a commentator on Super Bowl. What is LV2?
57.
Thank you. On behalf of the NFL Network and ESPN, Mr. Irvin was scheduled to appear on several sports commentary shows and to make appearances in the days leading up to the Super Bowl. He was also going to comment live during the Super Bowl game itself on behalf of NFL Network. Chosen for these engagements and viewed as most prestigious assignments in the field because of his reputation, skill, and professionalism as an NFL analyst. During Mr. Irvin's stay in Phoenix, he was told by the NFL to stay at the hotel, a local Marriott-affiliated hotel, designated as the NFL hotel for the Super Bowl this year. On the night of February 5th, when Mr. Irvin returned to the hotel, he was met by many fans who wanted to talk to him. He took time to shake their hands, have brief conversations with them, and take photographs with them. Witnesses have described Mr. Irvin as being jovial, gracious that evening, and behaving like you see him on TV. As he headed towards the elevator to retire for the evening, he was called back by a female employee, Ms. Doe, at the Dust Cutter, a restaurant bar located in the lobby of the hotel. The innocent and brief interaction, lasting approximately 1 minute and occurring in front of numerous eyewitnesses, ended with a brief handshake. Mr. Irvin then went up to his room alone and without incident. No harassment, assault, or inappropriate conduct occurred during this brief interaction between Mr. Irvin and Ms. Doe. The facts have been confirmed by multiple independent eyewitnesses. Eyewitnesses present in the hotel lobby area where this brief interaction occurred have also reported that after Mr. Irvin left, Ms. Doe returned to work without incident or observable reaction. I wonder what their statements are there. Upon information believed, no criminal complaints have been made to the Phoenix Police Department. I'm not putting a lot of weight there, or any other law enforcement agent concerning interaction. Defendants published false. Let's see what they said. That's what I want to see. The next night, while resting in his hotel room, Mr. Irvin was awakened by a security crew who removed him from his room and escorted him out of the hotel without any explanation as to why he was being banished from the hotel. Mr. Irvin was treated as guilty without explanation or even knowing the accusations being made against him. Upon information and belief, Ms. Doe complained about Mr. Irvin's behavior towards her to management of the hotel, including Renaissance and Marriott representatives and the NFL. Specifically, on information and belief, Ms. Doe falsely reported that Mr. Irvin had made lewd comments to her and unwanted physical advances upon her, and that she had been threatened and harassed by Mr. Irvin. Ms. Doe made this.
Have many problems with this.
I
have many problems with this from first principles, because I really want to know where the boundary lines are, and I think this is part of the problem. It's like, what are we allowed to do and what not we're allowed to do.
We don't. Well, here's the thing, Kurt. We don't know, and this is the crux of the problem. And I agree with you as a principle part, because everything that you're about to ask comes down to a pretty fundamental thing that we don't know from what we have in front of us. The video does not tell us what was said. Everything about that interaction can change based on the words that are used. And that's the problem I'm having with this. The words that are used. I think that this reaction,
it can't be purely.
I agree.
Be purely subjective. That can't be right. It can't.
No, I didn't say that. I didn't say.
No, I know. I was just thinking out loud. I'm sorry. That was my fault. I wasn't responding to what you were saying, and that was my fault. I apologize.
No, I didn't mean to cut you off. I was kind of agreeing with you. I didn't say that. What I agree with you that it cannot be subjective, and I know that people have had experiences that have caused them to view this one way or the other. That is a subjective approach, and I understand that people have those experiences. The question is, at what point in time and at what threshold, objectively, can an individual interact with a member of the same or opposite sex without being accused of this type of misconduct? What level?
Or even more the point, fundamentally, what is misconduct?
What is misconduct?
Yeah, because this is like a line drawing problem, and it can't merely be whether or not it's unwelcome, because how do you know that in the first instance, right?
Yes.
It can't be, because whether or not it's unwelcome, you don't know until it happens.
Correct. And that's the part where I think these dialogues, and when we talk about these cases,
I mean, obviously, if they tell you it's unwelcome and then you persist, that's a different story.
Yes,
but in the
exactly.
first instance, it can't be, it can't be a guy hit on me. I didn't respond to that. I didn't feel attraction, therefore harassment. That can't be right.
It is a difficult metric to measure. And the problem is when you make those allegations, when they are made, they do actual harm. Now, I'm not dismissing the harm that's done by the actual interaction, or can be done when the interaction is inappropriate. Again, talking about that line drawing thing that we were talking about before. But when someone comes out and says and reports to the media that what you have done is harassment, or sexual assault. We don't have to go back very far to see what that does to a career. Johnny Depp.
Right.
It destroys a career.
And then, like, you get into issues with what was Anan Azari, who was accused of things. And, like, it's like, if I believe every single word she says, I didn't see where he did anything wrong.
And so right now, there's not a whole lot of information. So it's just playing this carefully, not playing it carefully, but allowing the process. Yeah, y'all, hang on 1 second.
But I think it's an interesting question, because this goes to the earlier question we were trying to talk about when we were talking about sports and line drawing, right? We have to have rules. We have to know what the rules are. So you can't adjudicate whether or not this is bad without knowing where the line is, right? So you have to establish the line is, and the line is an issue of policy. But it's like, but part of the problem is, it seems like the lines are problematic because, and also, not for nothing, but people to use terms like sexual assault to refer to an entire panoply of conduct that is wildly disparate.
Now,
there's the term occasionally is used to refer to things that are, even if they're bad, they're not in equal categories of bad. In law, we solve this problem a little bit by having various degrees of crimes. It's like not all murders are the same. Murder comes in what, like 8 different flavors, because we realized a long time ago that they're not all equally bad. So
yeah,
but there's, at least in our society, there's not. Yeah, I'm sorry.
No, I was making a caveat to the chat. Finish your thought. At least in terms of our society, it seems like these lines of differentiation have become less differentiated, and they become blurred together. So that seems problematic to me. Yeah. And my caveat, the comment I was going to make to the chat, I'm getting notes from the mods. Do not. Your chat will be deleted. Do not put the full spelling of SA, the R word, or anything like that. YouTube will hit this video. If you put it in there, your comment will be deleted. And if you continue to do it, you'll be timed out. The reason why is I can't have that. I can't have those words showing up in the chat replay. The video is going to get struck. And the discussion is too important to risk the whole video going down. So please, please, please be respectful in the comments. There are ways that we refer to these things in acronyms or however. Just be careful, please. So here are the specific allegations. So this is the specific statement of what was said. Lewd comments to her and unwanted physical advances upon her. There's a lot of nuance in those words, and that she had been threatened and harassed. The threatened part, that threw me for a loop. The harassment part also, legal definitions of those terms, and it's just the lawyer in me that's going, legal definitions of those terms is very different than what I think people are thinking.
Yeah, unless you have multiple interactions, it's a little bit difficult to get to
Harassment's impossible to prove without multiple interactions. That's the thing from a legal standpoint.
Yeah.
So, yeah. Dove made the false report with actual malice, knowing it was the false. This is going back to that whole SA thing. If the action is by one of the participants in the room and the statement's made by the other person, if it's not true, it's actual malice. Easy standard. Further, no reasonable justification for the false reports. They were made for the specific purpose of damaging the image, standing reputation. Doesn't matter if it's for the purpose of, if that was the
that's confusing malice again.
Yeah.
That's not what malice is. Stop.
I know. Gosh, stop saying malice is malice. It's not malice. It means that if you knew it was going to happen.
Malice has nothing to do with malice. Why do you keep getting this confused?
Gosh. Oh, Ms. Doe made the false report with actual malice with knowledge as to its falsity of her statements. Further, no justification. Oh, I read that part. Upon information, belief, Renaissance, and Marriott by and through their agents, including Wazari reported the false information to the NFL, accusing Mr. Irvin of harassing and abusing a female employee. Upon information belief, Renaissance and Marriott falsely told the NFL that Mr. Irvin had been captured on video surveillance harassing. Oh, that is a different statement. Upon information and belief, Renaissance and Marriott told the NFL that Mr. Irvin had been captured on video surveillance harassing Ms. Doe and that he posed a potential safety risk to Ms. Doe and other employees of the hotel. That word, that phrasing is different than what the original report was. I'm curious. Renaissance and Marriott made this false report to the NFL with, at a minimum, a reckless disregard for its truth and falsity. Publication occurred within hours after Ms. Joe reported it without investigation before Mr. Irvin was apprised of the accusations or questioned about what had occurred. It's going to be very curious to see when that tape was pulled, because that should be recorded. No effort was made to elicit information from the eyewitnesses of Mr. Irvin himself prior to the publication. Further, there was no legitimate purpose for Renaissance. Look, if Marriott goes out and makes this statement, and if Mr. Irvin can prove that it's false, or if he says it's false and proves that it's false, Marriott not providing the opportunity or discussion with any witnesses, that would be actual malice, in my opinion. Kurt, your thoughts? They run with this statement. They have the two participants, one of whom they have not even ascertained whether they are willing or not.
I'm having flashbacks to Vic Mignogna and Funimation.
Interesting.
Where there was a very similar sort of fact pattern. Employee makes allegations to HR. HR does some sort of investigation, makes statements on Twitter that put him into a bad light. Vic Mignogna sues. And the legal analysis in that case creates similar problems here. It's like, yeah, I mean,
it's tough.
He's a public figure. Well,
actual malice.
It's public figure. He's a public figure. It's arguably a matter of public concern.
Okay.
So actual malice is probably the correct legal standard. They don't have actual knowledge of falsity because they weren't there.
But was it a reckless disregard?
Was it reckless disregard? Recklessness is more, to state the obvious, it's more than negligence. It would require basically active avoidance of the issue, and them saying we're going to trust our employees as a matter of policy implicitly, especially if it's like, well, this I don't know if this is true or not, but let's just say it is. She's been an employee for 10 years. We've known her to be a good employee. She's always been reliable, so we trusted her implicitly and took her immediately at her word. It's hard to then squeeze that into a reckless analysis.
This is tough.
So I have my doubts on the legal claims. Unfortunately, her report to HR is probably privileged for the same reason it was in Funimation. It's making a report for this official misconduct that's internal, and also you could get into an interesting issue as to whether or not the employee's report to their own manager is a report to another, because that's always a fun issue, because it's an employee in the company. So maybe it's the company talking to itself, so it's not another legally.
Well, that would be so. The first words would be from Marriott to NFL under that analysis.
Yeah.
And the thing is, so to clarify what Kurt was saying, based on the internal reporting, we're not saying that Irvin would have any right or opportunity to actually question the employee. That is actually outside of any analysis here. Marriott once receiving the information, Marriott becomes the acting party. And they have an opportunity or a choice, and they have to make a decision. And whether their choice in opting not to try and speak to Mr. Irvin is considered reckless disregard. Oh, this is interesting.
Yeah. And then the NFL takes that report at face value and acts on it, which is probably more of an issue of the NFL's internal contracts and policies and procedures as to whether or not that their actions were proper. But that's probably not rooted in defamation. It's probably rooted in some sort of contract theory.
That's contractual, and based on the NFL, I don't really take issue with them. If they receive a report from a hotel like that, I don't really take a whole lot of issue with them doing what they did and pulling it from the broadcast. Because if they're mid Super Bowl broadcast and this leaks, that's a whole lot of
no
questions they
joke,
don't wanna
right?
answer.
Yeah, no joke. So their best course of action, and most conservative course of action,
Remove him.
It's probably remove him because it removes the problem.
Yeah.
So
And then deal with the consequence later.
which also leads to this really uncomfortable possibility that I might ultimately conclude that he did nothing wrong, and also conclude that there's no one who can be held responsible.
Oh, Lita, this is sad. And I watch what you guys are saying. I can't pull up all the chats as they're being said. Thank you. But I do look at what you guys have to say. I am responding to that in due course. I am bringing them up, and I am talking to them even without bringing them up.
And at least part of this is me thinking out loud, because these issues need to be considered, and me saying, okay, where is the line for him, and then also like where are the legal issues. There's a lot of different ways of looking at this, so
there really is.
I don't know. I'm thinking out loud to try to work it through a thought process.
This is not an easy case in one direction or the other, and people are going to view it that way, and they're going to tell you it is in one direction or the other, because there's a lot of moving parts. There's a lot of lines that have to be drawn, and varying steps you have to go through before you get to any liability. Based on my observations, just based on what you're seeing here, I think Marriott's statement differs from that which was reported by Jane Doe. Again, this is the complaint. I am also seeing here, or in reporting, that it was, and there was a super chat to this effect. I wanted to pull it up. Stephanie Coker, thank you very much for this. Marriott's versions, including the filing they did after the judge ordered them a second time to give the video and after they had violated the previous court order, is my understanding. This is going to be a developing case. I'm not going to be able to, obviously, I'm going through the complaint because these allegations are been made. I'm going to be watching this case because it's of a sensitive nature, and I think it's important to have these discussions. So this is kind of the opening discussion. That's what we're having here. I'm going to pull the responses, and I'll try to see if I can go through those next week, because I think it's important that we kind of see all sides of this story.
Yeah.
This is a framework thing. So
here's further fun questions. If you assume that his perception is different than her perception of the thing, then it is possible that at least one of their perceptions is unreasonable, or maybe both of their perceptions are reasonable. But maybe one of them is not a reasonable person within some sort of meaning of reasonable. But it is also possible their perceptions are both reasonable, even though they're in conflict with each other. Because you also don't know, incidentally, what's going on or has gone on in her life. Maybe she has had some sort of problems in the past with other people who have sexually harassed her. Maybe she's overly sensitive because of problems she's had in the past, which are understandable. So maybe her perceptions are different than they might be for a completely neutral, blank slate kind of person. So, you have to, there's a lot of different ways of looking about this.
Yeah, I think this is going to be,
without knowing the exact details, it's a little bit hard to adjudicate in the abstract, but I have some doubts based on the video. I have some doubts on her claim. And
I have some
because at least
questions.
in my
Yeah.
mind, at least in my perception, it looked like a normal social interaction.
Mhm.
I didn't see anything that looked problematic to me.
And
I also
that's
have
a
some
fair
doubts
way of
on.
walking
I
around.
also have some doubts on his ability to get recovery for the legal issues we've been talking about.
Yep. And I think that that's a fair take based on what you saw. I also think that there's a fair take that can be viewed from the other perspective with someone who had different life experiences, who would have viewed that interaction differently than you did. And at the same thing, I think that we can look at all of those different perceptions and say that the legal merits of this case are complicated to walk through. And
Also, incidentally, while I'm thinking about it, I don't know where she grew up because the concept of personal space is very different in cultures.
very, very different by different places.
So
I don't.
it could be that she grew up in a culture where the concept of personal space is different than his. So there's also
that's possible. And the perception of personal space, oh my gosh, personal space is something where it's just, it's just, yeah. See right there. Trago said the same thing. They're both viewing the situation differently. The security guy had a chip on his shoulder. I don't know. The video doesn't tell me one thing or the other. It gives me a level of discomfort based on how I saw the media reporting when the incident first occurred.
Yeah, I don't think the video reflects the zeitgeist of the media, but tell me a different story,
media,
right?
Look, let's be honest. The statement here, and this is what I'm going to go back to, the statement that she made, Jane Doe's statement itself. Lewd comments, unwanted physical advances, okay? And that she'd been threatened and harassed. We've said the harassed part as the legal stuff is usually multiple times. I can see how in common parlance, people will use that without the legal understanding there.
And then she says threatened, and my immediate question is, what was the threat?
That was confusing. But the thing is, this is vastly different than what was being reported after this incident. And people saying, don't trust the media. Yeah, don't trust the media.
No.
I mean,
for better or worse, you hear NFL player involved in sexual misconduct against hotel employee. Your mind goes to places, or at least my mind goes to places that are way more extreme than what this video depicts.
That's an unfortunate consequence of the freaking experience I have in cases that involve all kinds of things. You would read these headlines and I would think to the worst cases I've ever handled, and I read the actual allegations and they're bad, but it's like, what the hell?
Yeah.
That was the only encounter. So
it's interesting. I find it interesting if people in chat are looking at that video and having the perception that is, it's interesting if people are saying like there's a problem there.
I know.
I find that interesting.
I'm trying not to bring my personal, what I'm trying to do, Kurt, and let me try to be honest here. I'm trying not to bring my personal biases into this, in the fact that I'm a male and I don't always understand how females perceive what I'm saying or doing. I try to be very aware of it, but I'm not always very aware of it. I do. I try to be very aware of what I say and how it impacts other people. I'm not always spot on. I can't speak from the female perspective. I'm not pretending to do so. I'm speaking from the male perspective, and I can see any number of situations where I have an interaction that on a video camera looks exactly like that is nothing anywhere near the negativity that I am seeing here. But that's also me. I wasn't a party to that conversation. So I'm trying not to judge what I'm seeing through one video without seeing what the other witnesses say. Hell, Johnny Depp, Amber Heard, pick your damn story. The number of people who jump to judgment after seeing one thing,
fair,
only to be proven wrong later.
Fair. Any sort of analysis we would reach at this point would be tentative, because we don't have enough information.
Yeah. And I'm seeing the comments. It doesn't have to be super violent. We can't expect someone to have to walk away. The words could have made her uncomfortable and feel threatened. I'm not disagreeing with any of these things. I'm trying to say like the legal standard here. Where's the objective opinion? And I'm not putting the cart before the horse. I'm letting the facts play out. That's what I'm doing. It's too early. This is a fucking complaint. That's what it is. Complaint is the very beginning.
Which also incidentally should inherently be viewed, at least in my view, every complaint should be viewed inherently with skepticism, because every complaint is if the attorney is doing their job, every complaint is written to maximize the grievance and minimize mitigation. So one of the things that you should do, in my view, is to try to correct for that, because you know that going in is to be skeptical. Because this document is not trying to be fair. It is the document is trying to be biased. It is necessarily it is one person trying to make the best possible argument from their perception of the facts that are presently available. And to the extent there are bad facts, they won't mention them, or they will mitigate them, and they will overextend to the extent they think possible anything that helps them. So you should view it skeptically. You should view all complaints skeptically.
Yep. I'm with that. So here we go. So going through, there's no question the damages were sustained. They were. He was removed from these different broadcasts. There's really no question. All of this entire case turns on the facts. And the facts are way up there about all this other stuff. So that's kind of a summary of what we know in the Irvin case to date.
Yeah.
The lawsuit's a $100 million lawsuit.
Yeah.
And that's kind of where everything stands. People are reminding me that I promised a Woods update. Tiger Woods responded. He said that she's full of shit. That is the quick way of saying it. Said that she chose to go litigate this in a forum that was inappropriate for the context. There were no allegations of any sexual misconduct or anything negative on his part. This is the Tiger Woods case, by the way. And he said she's full of it. I am waiting for that case to play out. That complaint made me more uncomfortable than the Irvin case. The Irvin case, I think, is a tougher factual call. The Tiger Woods case, I
was skeptical of that because they're trying to squeeze themselves into this fairly narrow exception that was just recently created in federal law.
Yeah, and they didn't allege actual behavior.
Yeah, it's like it felt like you're trying to use it as a wedge, which I didn't appreciate.
And that was how it was perceived, and that's exactly how Woods argued it. So here's what we're gonna do. We're gonna swoop. We're gonna do super chats, and I'm gonna leave us with a couple of funny little videos to make the night a little bit better. So swoop real quick, and then we'll get to some super chats and wrap things up. So now that we've covered all of the scary and sad things, let's go through this. Anna, I grew up down the street from a dear friend of mine. I'm hearing from a hearing family. She's deaf, from a multi-generational deaf family. Our cultural perspective on personal space is very different. That's an interesting observation, Anna, and thank you for sharing. Thank you for sharing that. I know people of different cultures whose perception of space is very different. Josh at Ten Hog, sweet dreams, Rob, Kurt, and chat. Thank you very much. M169, if Kurt's scenario is true, my husband and I wouldn't be married today. We met at a place of employment, grocery store. That's
this is also one of those interesting things, because when you talk about people dating within the workplace, not a lot of relationships came as a result of people working together.
Yeah.
So what exactly are the rules when it comes to a coworker dating, or even a coworker dating a superior, or what exactly are the rules? These are helpful things to understand. Can it really be the rule, like we're not going to allow anyone to approach anyone else within any sort of workplace? Is that really the rule we want to some degree? So there's normative questions here. Like, what really do we want?
It's what do we want, and how do we get there? And how do we get there? Yeah, I agree with you. Leader Randolph, Rob, it's more what he supposedly said to her, but it's she said, he said. He asked if she's ever had black in her.
Okay,
Lita?
if he said that, that would be an aggressively purient comment.
That would be an aggressively sexualized comment. I don't know that. I don't know. It's a question. Let's see. There's going to be statements made one way or the other. But Lita, I do try to grab these chats. I might get these messed up. I did see your chat before. I might take a little bit to get to them, but I do my very best. Chat is not the easiest thing to manage. It can be complicated. So I apologize if I didn't get to it in time. I hope that you still enjoy the content. Claude Simeon, thank you. Why do tortious and tortuous mean such different things when they are only one letter apart and both used commonly in law?
Blame the French.
Tortuous. I appreciate the joke. I appreciate the humor, Claude Simeon. Thank you. Shell, thank you very much. After a long week, it was good to have some light and deeper conversation tonight. Thanks for always having respectful conversations. Thank you, Shell. Very much appreciated. Danny, the insurance girl, thank you. Therapy taught me how to, 1, set my boundaries, 2, verbalize and physically demonstrate my boundaries to others, and 3, hold firm to them. Hours of work for a lifetime of social comfort. Danny, I'm very glad that did that. That is a very constructive and helpful thing for you to do. Setting boundaries is very important. Thank you for sharing that, by the way. Thank you. Missy W, she's a white female. He's a black male, so she's obviously automatically believed. Missy, I'm not believing one person or the other right now. I
don't know what it says about me, but up to this moment, I literally had not considered the races of the people involved. And now you've injected race into this, and now I've become instantly more uncomfortable with my entire analysis.
I honestly didn't even make an observation.
It didn't even occur to me to ask
who they were.
Yeah. Oh Lord. Okay.
I really don't buy into. I mean, I don't buy into that from my analysis, but hey.
It's gonna go back to where the world was colorblind. It was nice there for a second.
Mods might want to go to subs only. It looks like we've got a couple of the bots have arisen.
Oh, by the way, incidentally, I forget which one it is I use, if it was Nightbot or one of the other ones, but you can actually ban words and even in person's users names. So that's one of the ways I got rid of the bots, because every time one of those bots can, because they always use the same usernames. And the usernames are distinct enough. So I look for those key phrases. I'm like, anytime this phrase appears, even a username, just instantly time them out. It works.
Always the sex bots. The sex bots.
Yeah.
Always the sex bots. Thank you, Missy, though, for that viewpoint. I hope that I give pretty fair analysis one way or the other. Lauren L, thank you very much for the super chat. Very kind of you. As a lady, it's hard not to be apprehensive about some interactions, but at the end of the day, I try to go about by the rule of, if you wouldn't do/say it to your mom/dad, you probably shouldn't do/say it to a complete stranger. I agree with that rule.
I'm not trying to pick up my mom, so it's not quite right.
Oh, well, that's fair. Well, it's a complete stranger. I wouldn't say that it's a complete stranger part of it.
Okay.
I don't know that I would. Well, yeah. Oh, I see what you mean. Like the whole sentence, saying it out loud.
Yeah.
Would you like to grab a drink later? Yeah, that would sound weird, kind of saying to my mom.
Let's move on.
Moving on. Thank you, Lauren. Now I feel uncomfortable thinking about. Thank you, Lauren. I am now uncomfortable thinking about oh God. Okay, fair. Lita, thank you very much. Rob, I heart listening to you. You're the best. Thank you, Lita. Very much appreciated. Okay. So leaving things on a lighter note, let's see if I've got at least one video here. Let me see.
How are you doing, Rob?
I'm good. This week was wild. I had cases that were high contest that just became everything. Everything became everything all at once. Yeah. But every now and then, you know what the positive thing is? It's golf season. It's golf season. Do you know what we do during golf season? We golf.
We golf?
The last one. Wife call. Hey, babe, how's it going?
Let's move in the backhoe.
Good. Yeah, just at work here. Yeah, just sitting in the Bobcat. Yeah, they needed me to come on site today. They can't do it without me. Yeah, doing a little lift and relay for the city here. Yeah. Well, say hello to the boys. Look at these guys. They're a disaster with them.
Somerville. Hey, when's lunch?
But don't worry about lunch. Keep working. Yeah, no, I can't get the kids tonight.
You get
no,
the measurement?
I'm going to be here till at least 5 o'clock.
10 and a halfer?
Yeah, but what I can do is I can bring home some dinner.
Got the piece. Grab
Yeah,
the
I'll bring home like
bandsaw.
3 or 4 Costco chickens.
What's Craig doing? He's doing nothing over there.
All right.
See what's going on over here.
Yeah, I'm going to have to let you go here. It's getting a little bit chaotic. We got a delivery coming in about 2 minutes here.
Get your ass up.
Okay. All right, I love you too. I love you. Okay. Bye. 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 Boys.
Dude, man.
What are we looking at here?
We got 160. Behind us.
You got to appreciate the ingenuity. You have to appreciate the ingenuity. So, and then what was another one I had? I had one more. You know what? We need two to get out on. Oh God, I don't know if I'm gonna get hit with a copyright on this one.
I suppose
I will.
We could mention the fact that that is a TikTok video, and TikTok may not be long for this world.
That's true. TikTok might not be long for this world. Did you catch the FTX still has their TikTok page open, including Tom Brady infomercial, like his doing advertisements?
I did not know that. That's funny.
Yeah. Yeah. Like just people are not the most intelligent. Okay, what's the last one? Let's see. If you ever had that's a contractor joke. I don't know if people get the contractor jokes, but people tend to enjoy some of the no, not that one. People do. I don't know why. I don't know why they find it funny. But they always do.
I pretty much don't know why.
I don't know why about a lot of things. I don't pretend to know why about a lot of things. Things confuse me all the time. Make sure
Questions fill my head.
Blue cheese and banana smoothie ain't nothing. Real men eat fermented shrimp and rice in a jar. Do you have any fucking idea how long it took me to get my hands on this shit? I had to go to like 3 different stores when I got off work. And there is a solid plug of complete mystery meat in here. What does this say? Treat yourself to an exotic taste of Navarro's, whatever fucking word that is. Prepared from freshwater shrimp, precisely fermented to achieve perfect sourness. That just gave me a fucking ulcer. Why on earth? What? Sour fish, my favorite. Let's get into this. Lucky for me, I see there is a little bit of juice in there. What the fuck? That is aromatic as hell.
Oh.
Look at this.
Oh no!
Are you shitting me?
You will be later, I think.
Shrimp and rice never hurt anybody, right?
Why does this make me laugh? That's aromatic as hell. The pain.
Oh my god. You know, it's times like these that maybe we should take into consideration that sour fish should be on the front, right? Well, fermented kind of gives it away, but there's so much going on in each little bite that my palate just doesn't know how to handle it. Let's try.
Nope.
Stay down, bitch. We're fine. We actually enjoy everything that is going on in that bite. Now, if you guys could please do me a favor before I throw up.
Okay. People ask for the contractor one. Here's the contractor one. If you see a contractor walking with Ryobi tools.
So,
Oh my God, it's actually worse
if
than
you
I
could,
thought.
if everyone could call 202-456-1111, that is the White House opinion line, and let Joe Biden know that they need to immediately sign whatever it is to ban TikTok. That'd be great.
Ban TikTok.
Please call them.
Do
it now.
Watch that. You know what though? These are on like Instagram Reels too. If a contractor shows up to your house and they have Ryobi tools, run.
Yeah, there's a problem. Oh my God, it's actually worse than I thought. Are you alright?
Yeah. It's really hot.
Yeah. You good?
Did you need a garbage can or?
For what? Like the scraps or like?
Oh, I guess you brought your kid to work today. Where's the little guy?
I don't have any kids.
No.
What do you mean?
Oh, you got the Ryobi.
Yeah, they're good, man. For the price point, they're great. Like working with these is just fantastic.
Yeah. No.
Yeah. No, they're awesome.
Yeah. You know what? After looking at this, I think I'm okay with it. It's kind of growing on me.
Yeah. Just the water damage in your house, you're fine with?
Yeah.
Really?
Yeah, I think I'm okay with the water damage in the house. I've been looking at getting an indoor pool. The kids would love it.
I could do this right now. It'd take me like 30 minutes.
Yeah. No, it's good. I like this how it is now.
Yeah, you'll inhale the mold that's just coming down your walls?
Yeah.
Okay.
Yeah.
Okay.
Thanks for coming by.
Yeah.
Thanks for the quote.
Yeah. Anytime.
Yep. Allie, you're not like a professional contractor. Those tools last great for single projects. Oh baby, not for long-term use. And the last video that we're going to be going out on tonight, I want to make sure I hit the last super chat before I do. Complete strangers are people you've never spoken to. At least say hello and ask their name. I enjoy saying hello and asking people's names. It's fantastic. But the one we're going to be going out on, which I think is probably one that we all need to see, and YouTube's going to have a problem with it. I don't really care because it's something that we all need in our life. And I will trim this out if I need to, but YouTube be damned. Okay, now do we feel better? All right. Everyone, please, Kurt has been, we have not had the interaction that we've had. Well, I've not had the opportunity to talk with him as much as I wanted to the past few weeks. I'm glad he was able to make it. Please go check out his channel, Uncivil Law, great legal takes. There's some Supreme Court cases, opinions coming out this Tuesday, right? They're releasing them?
I think so, yeah. I'll double check the Scottish log.
Okay. And I would be remiss.
There's great stuff coming down. There's a Twitter thing, of course, I still need to do the Twitter oral react. So if you've got like 3 hours free that you want to spend,
Dude,
let me know.
that case is wild.
Yeah. I think Twitter's gonna win. I'm sure.
You think so?
Yeah. It can't possibly be true. Because the theory of the case proves too much. It proves too much. Twitter merely by offering a generally available service is aiding and abetting in international terrorism.
It was wild.
It's a lot.
The argument was a stretch. The 231 that was a.
Well, it's not even really a 230 argument because there's a special. Here's what happened in the Twitter case, right? So in the Google case, it was a 230 case dealing with the Google's algorithm, and the arguments were no good. In the Twitter case, it's not even a 230 case, strictly speaking. There's a federal statute that allows anyone to sue in a U.S. court for any international terrorism anywhere. So the U.S. government has provided universal jurisdiction in the United States for terrorism acts. So you can sue anyone for any terrorism act anywhere. It also extends to aiding and abetting terrorism. The idea is that, and the Twitter is aiding and abetting terrorism merely by providing a service that's generally available and that terrorists use to spread their messages propagandize, DM each other, or whatever else it is they're doing with the Twitters. And it kind of proves too much. Like, and under this theory, by the way, Twitter doesn't have to have specific knowledge of any particular incident. Like, they don't have to know. Because normally when you're thinking aiding and abetting in a crime, like, you have to know the crime is occurring or you're facilitating a particular crime. But under their theory of the crime, like, if I open a grocery store and they come buy water from me, that's aiding and abetting, because the terrorism will drink it and be liquid. They will have water. It's like, that can't possibly be true. The theory proves too much.
It's a lot.
So Congress wrote a broad law, but probably didn't mean it that broadly. So yeah,
That's a lot.
it's a lot.
I would be remiss if I did. So hang on, one more super chat. Bop it, Barab. You know I do some woodworking. I refuse Ryobi tools. Well, they're good for one-time use, but anything beyond that, no. And there were gifted memberships that I almost forgot. Joshua Ten Hag, thank you for gifted memberships tonight. Brentwood Chic, thank you. Ali Foley, thank you. Neurodivergent Counselor, thank you. Anna B, thank you. Jesse Charles, thank you. Mav, for a gifted or for membership chat that you sent earlier that I missed. I'm sorry. StreamYard needs to fix this because I hate not being able to see them and star them. Disney Mom, thank you for the gifted memberships. And Equality, thank you for the gifted memberships. I need StreamYard to fix that. I need them to fix that.
At least on Melon, which is similar to StreamYard, it does pop up, and you can have it pop up, and it does show up for gifted memberships. So
I need to fix that. I need to figure that out because it's too generous of a thing for people to give for me not to be able to highlight that. So thank you guys for all of those gifted memberships. Again, Kurt, thank you for joining this evening. Thank you guys for another 5 hours. It's been a while since we did one this long, but
yeah.
Until next time, we bid you all a good evening, and I hope you have a wonderful weekend. Enjoy the rest of your night, day, and weekend, and I'll see you next time, okay?